is going to be testing the emergency alert system, which means every person's cell phone in this courtroom is going to be going off.
We'll take a break.
The test is apparently starting at 2:20. It's nationwide, and it will go for 30 minutes.
30 minutes.
What?
My hope is that everybody's cell phone will blare at 2:20, and we can just take a break at 2:18 in the afternoon and be back, 10 or 15 minutes later. But understand that I don't have any control over the nationwide test.
Is that going to blare for 30 minutes? No, it can't.
Well, your cell phone is going to blare for about 15 or 20 seconds, but it might take 30 minutes for everyone's cell phone to blare. And having been in court with jurors present, when everyone's phone starts going off, it's not a very happy time. So please arrange yourself so at 2:20 we can take that break.
Yes, John.
Next, Mr. Anderson, do you
Could
have
we go back to tomorrow?
tomorrow?
Mr. Anderson and team have been kind enough to give us their lineup for tomorrow, and I hope the exhibits. There are two witnesses that may require a proffer. There's two lawyers that are on the list, Mr. Zimmerman and Mr. Kelly. We're not aware of what knowledge they have of any of this other than the DCF action. And so we're going to need to have a proffer on what they're doing or what they're going to say in order to do it. We also don't need to do that now, but it needs to be figured into plans.
Your Honor, for the record, neither one of them are going to testify about what happened at the DCF proceedings. They are going to testify about their ability to speak to their client confidentiality and how the hospital interfered with that. I don't anticipate their testimony being very long. I think also they'll testify about the fact that, contrary to certain representations, that Maya loathed Beatty and hated being there, and although there was one or two nurses that were okay to her, most everybody was not nice. So that's the sum total of their testimonies.
And when were you anticipating these witnesses testifying?
Well, Mr. Zimmerman is in Europe, so we are working out times with him. We would hope it would be the end of the day, around 4 o'clock.
Well, if he's in Europe and you want at 4 o'clock, that's probably putting him, 9 p.m., 10 p.m., depending on where in Europe he is?
Yes, I spoke with him about it. And I still have not personally spoken with Mike Kelly, but I'm informed that someone from my staff has.
Well, given what Mr. Anderson just said, do you still think there's going to be a need for a proffer?
I don't think so. But
You do not?
if they're not going to implicate DCF at all, or the dependency action at all, then I don't think a proffer is necessary. But you've heard what I heard.
Okay. Well, no DCF issues?
No, I'm not asking questions that involve DCF.
Okay, well then,
How the minefield turns out is anyone's guess.
what's the next issue?
Plaintiffs move for a mistrial based on the failure to allow the entry of the evidence of Maya Kowalski having been sexually assaulted at Johns Hopkins Children's Hospital. We will follow up with a proffer from Maya Kowalski of exactly what happened. We note that both Jacqueline Henschke and Dr. Katzenstein from Johns Hopkins, Dr. Henschke, independently have verified this, and we have an independent witness. Still, we understand the court's position on this. However, since we have, I believe we can show that the defense has known about this for a considerable period of time before we ever had voir dire, and if once we get a transcript, we can show that questions similar or about this were asked during the course of the voir dire. I don't know the exact wording, Your Honor, and you were there too, but I believe we went into the extent of battery. That's just from memory, and your court may remember it different, but I remember the subject came up. Now, whether they were asked or not, we'll have to see. If, in fact, there was enough brought up so the court feels comfortable on that, we hope to be offered a rehearing on it. There are other bases, but at this point under the case law, we ask the court to suspend any ruling on that till the end of the case. The parties have spent enormous amounts of time and money. This court has spent enormous amounts of time getting this case to trial, and it would be an abject shame if we had to terminate it after all this work we've done. 5 years, 52 summary judgments this court has heard, and we don't want, at this point, for the court to stop the trial. We want to move forward. We simply want to note for the record on the present second DCA case law the importance of this testimony.
So you're moving but not moving for a mistrial?
I am moving but asking court not to rule until the end of the case.
Well,
I believe I can do that under the present case law. If I am in error in that, let me know, because I may then withdraw that motion.
the defense objects and believes that the plaintiff has mischaracterized the mistrial rule. We would ask the court to deny the motion for mistrial. I can give the basis, but procedurally, that's not something they can defer until the close of evidence. We would ask that to be ruled on now before this entire tribunal spends 6 more weeks in enormous expense. I can respond further, but if you want to take it one at a time, you can, or I can lay the record.
Now's the time if there's anything you want to say on the issue.
I do want to say one other issue. I will tell this as an officer of the court. I've spoken with Dr. Katzenstein. The note that she wrote is specifically this, quote, "She denied a history of sexual abuse." This is coming from Maya. Quote, "She stated one time previously a doctor had looked at her private parts but did not touch her, and it made her feel uncomfortable. I've spoken with Dr. Katzenstein. Her testimony in this court will be that Maya told her that that was from another hospital. That was not at All Children's Hospital. Dr. Katzenstein will testify that there's a very strict protocol at All Children's, and that she specifically would have asked Maya, did that happen here? Because if it did, it would have triggered an investigation. So for the record, All Children's absolutely denies, based on what Dr. Katzenstein's testimony will be, that she was told about some type of an assault, or really what's being described here, how it's being described, inappropriate conduct that occurred at All Children's Hospital. That being noted, in terms of the surprise, I think Your Honor's already laid out nicely, the prejudice in terms of jury selection being at this point in the trial. We would just note that there's no way we could have known about an allegation that the plaintiff themselves said they were completely unaware of. And the note from Dr. Katzenstein does not say that there was something that happened at All Children's and she will disclaim. That's all, Your Honor. Thank you.
Anything else? I know Mr. Hughes was whispering in your ear.
No, really. Nothing else, Your Honor.
Anything in rebuttal?
Yes, Your Honor. Maya Kowalski would be the best witness as to that, and it would be very interesting to cross-examine Dr. Katzenstein, given the absolute obligation, once that was raised, as to anyone, anywhere, by a child to report that. So we will welcome the opportunity to cross-examine Dr. Katzenstein on that. The biggest concern is Dr. Henschke's records, which the defense has had since March of 2022, and which have much more detailed information pinpointing where and how this happened. And so it's still not complete, but it certainly would put any reasonable attorney on notice that this had occurred. We did not, because we were attempting, if the court will recall, to make Dr. Henschke a safe harbor for Maya. so that she could tell Dr. Katzenstein anything that she wanted so that it would help reduce the stress and strain on her. That did not happen, and through the course of the deposition of Dr. Katzenstein, which was on Zoom, that was never asked. And I confess that we didn't start going over a lot of the records until Dr. Katzenstein was flying in. Had, of course, our client informed us that this was something that was going on, we would have looked again at Dr. Katzenstein's records, and we would have probed more of the records of Dr. Henschke to be able to bring this to the court's attention. Basically, that the defense had greater knowledge at this point, the record I believe shows, than the plaintiffs did, given the plaintiffs, Maya Kowalski's direct denial for 5 years, not denial, but failure. She didn't deny it. She just failed to tell us about it for 5 years. So, frankly, I wasn't on the lookout for it.
Okay, the issue has to do with whether to grant plaintiff's motion for mistrial. It appears the plaintiff is contending that the court made an incorrect ruling on the denial of allowing the newly discovered evidence, if that's the phrase we're going to use, into this trial when that is outside the pleadings and was not disclosed to the court and potentially the defense until after the jury had been sworn and the trial started. The court does not believe it abused its discretion in denying the motion, and I laid out earlier this morning the court's view on that particular issue. I'll reaffirm that ruling, and because there has been no violation to the plaintiff and no prejudice to the plaintiff, at the end of the day, this still was within the ambit of the plaintiff's knowledge. I understand the circumstances may be such that Maya Kowalski didn't recollect this until more recently, but you know, we are where we're at. I don't believe there's been any incorrect ruling, and so I will deny the motion for mistrial.
We understand the court's ruling. Let me continue. We have one more matter.
Next issue.
The court had requested, I think twice, for us to come up with a stipulation as to the lien issue, and if I could pass this up to the court, and we prepared a copy of it for the defense counsel.
Did you give that to Mr. Anderson?
Yeah, he's got it right
Oh, he has it. Okay.
Is this something that is agreed to?
No,
or-
we haven't seen it.
Yeah, we'd prefer to have some time to look at this and maybe address this after the jury's gone for the day, rather than hold up the jury for the day.
Well, if they haven't agreed to it yet, it's not yet a stipulation.
I understood, Your Honor. The only caveat we would put in the record is that there'd be no objection if this stipulation, well, based on the results of this stipulation, to Jack Kowalski being recalled to address some of this issue.
No objection.
Anything else before?
Just briefly, Judge, they told us I'm sorry, Mr. Anderson, were you not?
Yes. We plan to ask Jack Kowalski about the Aetna billing records, which are in evidence. And then there is another email of 2438, and it's a series of messages between Aetna and Beata Kowalski. We're not so much concerned about the Beata Kowalski input, although we believe that should be relevant to under.
You said 2438?
Yes, 2438.
Is this on the list for today?
It was on yesterday.
It was on yesterday's list.
No, I don't have the actual thing because it was not on Jay's list.
What was it on his list?
That's what he's saying. I have to find that list.
Mr. Anderson, Mr. Whitney, could you put up on the screen so you can see?
Yes.
2438.
Do that.
Here it is.
Go to page 3.
I don't have the actual document though.
Need to screen draw.
Oh, screens need to turn on, Your Honor.
Oh, I apologize. Mr. Reyes, you should have it now.
Thank you.
It's kind of hard to read, but can we enlarge that a little bit, Danny?
Yeah, I recall these vaguely, Judge. They're like almost illegible. They're hearsay.
Mr. Reyes, can you make it larger for me, please?
Yes, sir. Just the top third. That's good.
And what's down below what's highlighted?
That's the email that Beata sent. We can show the court.
Okay, but what's,
12/28/16.
Keep going down. That's good.
Is there a way to enlarge it any more and kind of center it so the court can see this a little better? And me?
I've read it now.
How long is it?
Is that it?
Is it just those 2 pages?
Oh, we'd like pages 3, 003, 008, and 013.
Okay, you've only shown me one page.
And show the court then.
008?
Yeah, 008.
Yeah, can you go to 8?
It's part of a thread.
They're all substantially similar.
And are all these just specific requests by Beata Kowalski for what is the diagnostic code? And then the response is whatever the response is?
Yes, Your Honor.
Yes, Judge. That's the relevance.
Ms. Quarles?
It is. No objection.
So,
But it's just those 3 pages though, right?
Yes,
Can I have
Your
the
Honor.
numbers again, please?
Yes, sir.
To the last page.
It's 2438, 003, 008, and 013.
Can we see 013, Judge?
please.
Dan, can you put 013, please?
Same thing, if you can enlarge it, so.
Right. All right. No objection, Judge.
Court receives, without objection, Exhibit 2438, pages 003, 008, and 013.
I mean, not right now.
Okay.
Anything else, Mr. Anderson, before I go to Ms. Quarles, because she has an issue?
2017.
It's in.
Yeah,
It's in.
all right. No, Your Honor.
Ms. Quarles?
Just a request, really. They've listed 3 depositions that they're playing tomorrow. One is Dr. Johnson, who I think is fine, but if they could get the edited versions to us tonight, as opposed to in the morning, it's very difficult to do it on the fly, to compare what they're done. So we need the edited versions tonight. They should be already edited.
I'm looking at Mr. Reyes. I don't know if this is your issue or someone else's issue.
I'm just having it emailed over this very moment. Oh,
The edited version?
the edited version. We are edited as to now.
Rebecca Johnson.
Yeah, Rebecca Johnson, and I thought we had worked it out with Kathy Beatty.
and Dr. Napolitano's done, and then
Dr.
BD,
Napolitano, and who else?
There's 3 issues with BD that need to be addressed. Aside from that, that's the only videos I've been editing.
How long would it take you to edit those?
I can do BD in 5 or 10 minutes.
During this witness.
As soon as we've
But we have
gotten
to
those,
deal with this.
and we'll email them over. We're 5-10 minutes away from BD, but the remainder of them can be shown, and we'll send them over. We're sending
I
them
thought
over
BD
now.
was today. I think Ms. Corrales is talking about tomorrow's.
Right, right. He said, what I heard is they're done Napolitano
Yes.
and Perno.
Perno, I believe.
No, unless the reason, never mind. Tomorrow, we've got Dr. Cantu. assuming he
It
gets
seems like
in.
Mr. Reyes and the young lady, and ma'am, I don't know your name. I apologize.
Samantha Lawrence, LAW.
Miss Lawrence? Okay. That Mr. Lawrence and Mr. Reyes seem to know precisely where they are with this. So can you tell us where you are on the ones for tomorrow?
Rebecca Johnson, Dr. Napolitano, and that's for today. We're checking on Bruno right now. But for sure, Johnson and Napolitano.
And are they for tomorrow?
Yes.
For tomorrow, they're complete.
And so the defense has received them?
Yes. And we've gone back and forth on Napolitano and Rebecca Johnson.
I'm now looking at the defense team, those who,
We don't recall receiving Napolitano unless it's come in while we've been in court.
I think
you-
it was last week.
it was
because
last
we had
week.
the
You
All right,
objected
we'll
to the-
double check. We silly could have missed it.
It was, yeah, there was one objection at the end that had to be removed. and then
Okay.
The
All
edited
right.
version was sent over.
Thank you. We'll check on it.
Your Honor, we would prefer this afternoon, looks like we're only going to get one depot plate, if any. We prefer that to be Catherine Beatty. There's 1 or 2 discrepancies as we've been going back and forth over lunch. Mr. Reyes is working on them. We've just asked that Mr. Reyes and whoever from their team step out so we can reconcile this during the next 2 hours of Mr. Kowalski's testimony, so we can start with Beatty after he's complete.
Judge, we've given
There'll be
him,
cause.
there was one piece of testimony that should have been removed and was inadvertently overlooked that we objected to. And then there were 2 that they objected to, that we pointed out to them, were inadvertently left in. And we've given that to him, so I don't know why we need to step out.
Well, I just want to make sure you view it and you get the okay before we play it after Mr. Kowalski. That's all.
I think
So long as
we
we
can
remove those, you're okay?
trust that you're
Okay.
going to remove those 3 things.
All right, we'll remove it and we'll proceed with Beatty.
so Mr. Reyes, did you get the 3 issues that Ms. Corrales was talking about?
Yes, I've got the 3 designations, but there seems to be
Just remove them.
I think there's a question because one of them starts in the middle of an answer, Judge. It was one where you sustained and overruled part.
There was a precatory phrase in one question. Is
No,
that
that
the one?
came out.
That came out.
Judge. This was their objections to our designations, and you overruled part of it and sustained beginning on 108, and it's in the middle of a question, or answer. I think that's the question. Is that correct, sir?
yes, there's a partial answer, and then and when I saw our filing for the designations, they're saying that I need to remove or delete a page and line section when it's not shown as a sustained objection. So
Okay, we got
can't
that
admit
wrong,
that.
but,
Let me talk about it on a break.
yeah, we'll talk about it on a break.
So it does sound like BDs can be played today, if we get there. So let's try to get there. Mr. Kowalski, if you could come on up, let's bring in the jury. And Mr. Kowalski, I will ask you to remind you that you're under oath, but I'll do that in front of the jury.
Yes, sir.
And how long is the BD deposition?
At its current, it's 1 hour and 35 minutes, but it's 2 volumes, so one video will end. The other one.
Okay, everyone, please be seated. Members of the jury, I want to confirm that while you were away, you did not discuss this case amongst yourselves. You did no investigation and received no information. Is that all correct? Correct. And that you have not seen any media coverage of this while you were enjoying your scrumptious lunch. And that you have not been approached by anyone about this case. Is that correct? Okay. Mr. Kowalski, just wanted to remind you, you are still under oath, sir. Yes. Mr. Anderson, you may inquire.
May it please the court. Mr. Kowalski, we were on the topic generally of the health insurance. I'd like to show you what's been marked as Exhibit 2017. And for the record, that's the Aetna health insurance records. And we want to start there with page 699er. So that's 2017-699 trial exhibit. All right. Now, have you seen these before, generally?
Some of them, yes.
And, best of your knowledge, the entire records and evidence you provided to us?
Yes.
Okay. Let's look at how we read these. Across the top, there's a claim ID. Do you see that?
Yes.
And the date received, what's the date there?
Date received, not the run date, correct?
Correct.
I'm sorry, 10/19/2016, 1/6.
All right. October 9th, 2016. So can you go down there past number of services 1 to charge submitted?
Yes.
Okay. Now let's go down to the diagnostic code. Do you see that?
The POA code?
Yes, right under the number 1 there.
Yes. You want me to say it?
Yes.
No, complex regional pain syndrome. Then an I, comma, unspecified.
All right. And to the left of that, there is a code. Can you read
Diagnosis code?
that? Yes, the diagnosis code.
G as in George, 90.5D as in David.
All right. I'll ask you to then take a look at trial exhibit 2017. Yes, 2017-663. You have it there?
Yes, I do.
And let's enlarge it a little bit so everybody can see. Okay.
Yes.
Now, first, what was the date of this? Date received?
Date received is that supposed to be 08, I would imagine, November 8th, 2016.
All right.
Almost
And-
looks like a D.
I see. And then under the charge submitted, how much?
Charge submitted, $10,679.
Amount paid then?
$5,005, is that 80.24?
All right. And then who submitted it there under provider name?
I object to the foundation of the leading in the reading of the record.
On this one, I'm going to overrule it.
The provider name is Johns Hopkins All Children's Hospital.
All right. So if you go down there to the POA code, which is down about a third of the way, do you see it there?
Yes,
With
I do.
The diagnosis code. What is the diagnosis code?
Complex regional pain syndrome, and then that's the I other specified site.
Got it. Now, let's go to,
Mr. Anderson, I apologize. What was the exhibit number?
I think that,
2017 is
yeah, 2017,
And the page number, sir?
663.
Thank you.
All right, so let's then turn to 2017-726, if we could. Actually, no, I take that back. Let's just go directly to 729. And we're going to do the same thing again, if we could. Mr. Kowalski, once it comes up there, and we'll enlarge that as best we can. All right.
Received date?
Yes.
11/08/2016.
All right. And what was the charge submitted?
$50,071.
All right. And so who was submitting that?
Johns Hopkins All Children's Hospital.
And there's a lesser amount shown actually paid. Is that right?
Yes, $28,039.76.
Now, okay, let's continue on there. The diagnosis code again?
The first one would be complex regional pain syndrome, I of other specified site.
All right. Let's look then to 2017-738. And,
Received date?
yep, received date.
December 6, 2016.
And who submitted it?
Johns Hopkins All Children's Hospital.
And charge submitted?
$10,005.
And what is the first diagnosis that they put on there for the purposes of billing this?
Complex regional pain syndrome.
Let's go to 2017-739. And it is about halfway down the page if you start there under date received. Not the top one.
December 6th, 2016, and I believe that's $90,810.
Okay.
$50,853.60 was paid, and
who-
that was
who-
submitted by Johns Hopkins All Children's Hospital.
And then what was the top code there?
Complex regional pain syndrome, one other specified site.
All right, well, let's go to 2017-741. All right,
Date received?
yep, start in on it.
December 6th, 2018. Charge submitted, $18,480. Amount paid, $10,348.80. Provider, Johns Hopkins All Children's Hospital. First code is complex regional pain syndrome.
All right, so let's go to the next page, which is 2017-744.
744.
Yes, please. Now, if you go down there to the bottom of it,
Diagnosis code?
what I'm looking for here is the provider name and provider number there at the bottom right. You see that?
Yes.
And who was the provider here?
This is that one. I'm going to mess up on her name. Jennifer Kettenstein?
Right. And what kind of doctor was she?
I believe that was the psychiatrist.
Right.
I could be wrong.
Okay. And then charge submitted?
On the bottom,
Yep.
$255.
And
And
what-
$108.28 was
And what was the diagnosis?
complex regional pain syndrome.
Let's go then to 2017-754. And so who was the provider there from Johns Hopkins? At the bottom right.
Yes, Richard Andrew Elliott.
Now, do you recognize that as one of the doctors that, again, was a psychologist or psychiatrist
Objection.
at Johns Hopkins?
Objection, misstates evidence.
Overruled.
I think he was the anesthesiologist.
That was right. He was the anesthesiologist. And so how much did he charge?
$255.
All right. And so what are the two diagnoses there?
Well, you have chronic pain syndrome, pain unspecified, complex regional pain syndrome of the lower limb, bilateral, and
Okay.
then complex regional pain syndrome, unspecified.
All right. So then let's go to, and I'm almost done, 2017-767. And let's look at the date received.
Date received is January 5th, 2017.
I'm sorry, Mr. Anderson.
Yeah, it's 767.
Thank you, sir.
And the amount charged?
$78,702. Amount paid was $44,073.12.
And who was the submitting party there?
That was Johns Hopkins All Children's Hospital.
Looking down those lists, can you tell us whether complex regional pain syndrome was one of the
Yes.
codes?
Oh, I'm sorry. Yes.
Now, have you been through the records sufficiently so you can tell the jury whether, if they were to review all of these records, they would find?
Significant amount.
I object, lack of foundation.
Overruled.
There's significant amount of charges for complex regional pain syndrome.
So now, throughout these proceedings, did Johns Hopkins hold out to you and the public that Maya did not have CRPS?
Objection, mischaracterization of the evidence, lack of foundation.
Sustained.
Let me show you in evidence 24308. And specifically, this will be 003, 008, and 013.
Okay.
Okay,
Could you blow that up?
okay, if we can start there
Okay.
at the bottom. Now, this is from your wife,
Yes.
and the date there is.
I believe it's 12/27/2016.
And what is she asking?
She's looking for the DX codes
DX means
for
that.
this, and is that Bill? It's hard to read.
Do you know whether DX is a medical abbreviation for diagnosis?
Object to the leading art.
I'm unaware of what DX was. I'm sorry.
Overruled. The answer will stand.
All right. So
I'm sorry.
let's look at the top there. There is a response.
Yes.
All right. And what's the date of the response was sent?
12/28/2016.
Right. And going down, who is it addressed to?
It was billed by Jenny Dolan to the following DX codes. And the DX code below is complex regional pain syndrome, lower limb bilateral, and then also complex regional pain syndrome. I believe that's that I unspecified as well.
So who obtained the codes to allow you to decipher this?
This here would have been Beata.
And what was that effect when you found out that Aetna was charging back your health insurer for complex regional pain syndrome?
Objection, misstates the evidence.
Sustained.
Charging Aetna. What was your reaction when you saw that the number one diagnosis put down by Johns Hopkins was complex regional pain syndrome?
It was alarming to see that because we were told she did not have CRPS.
And through your entire stay there at Johns Hopkins, can you recall them ever coming in and saying anything to the effect of, well, we've confirmed now that she has CRPS, or did they maintain constantly that she was in her head?
Objection to the them primarily. Objection to the hearsay.
We're going to sustain on the first basis.
When, if ever, did any Johns Hopkins doctors come to you and explain or state that she really did have complex regional pain syndrome and it was not a mental issue?
They did not.
Through this period of time, to the best of your knowledge, did the doctors and nurses at Johns Hopkins All Children's Hospital continue to maintain to you that your daughter's problem was all in her head?
That was on the discharge papers that it was fictitious or conversion disorder.
Okay. Do we have that discharge notice up yet? We'll continue on. We'll come back to that. All right. In follow-up to some of the other questions, did anyone at Johns Hopkins ever explain to you why Sally Smith was in a lab coat and could gain, strike it. Did anyone from Johns Hopkins ever discuss with you Sally Smith, Dr. Sally Smith, having access to Maya's medical records on October 8th?
Yeah, objection. Yeah, we need to approach on this one.
You may continue, Mr. Anderson.
Your Honor. You need me to restate?
I know part of it.
Did you ever give Sally Smith, Dr. Sally Smith, any permission to access your child's medical records on October 8th, 2016?
Just to preserve objection on our same basis.
Overruled.
No.
Did you ever give Dr. Sally Smith permission to enter your child's room unsupervised?
No.
Do we have that discharge notice yet?
Yeah, it's 100.
It's
1002.
We need that. Okay. This is the Johns Hopkins records 1002-0002. We could bring that up. Just the one sign.
Start on 1, finish, start the first page. It's not there, but you pull on 1.
Which one?
1. There's one before it on that. I don't have it.
But it's on the screen. All right, let's go to the page before that, which would be 0001. It's not in the book. All right, we can enlarge this. Have you seen this before? Discharge summary?
Yes, I have.
All right. And so what's the date here?
That would be Friday, January 13th, 2017.
Now, how many days after your wife's death is this?
5 days.
Was one of the theories that your wife was controlling Maya somehow to induce her to fake her symptoms?
Objection, again, mischaracterizes the evidence, also vague as to who.
Sustained.
Was there a claim by the hospital, to the best of your knowledge, of Munchausen by proxy involving your wife?
Yes.
And are you familiar with the term Munchausen by proxy?
Yes.
And does it include, best of your knowledge, a claim of manipulation by a parent over a child?
Yes.
And in this instance, was it directed at your wife, Beata Kowalski?
Yes.
And so, how many days had your wife been, and I'm sorry about the term, out of the picture as of January 13th, 2017?
Oh, from January 7th, you said, or 8th? I'm sorry, about approximately 5 days.
And so 5 days after is when you got your daughter back?
Yes.
Now, did you receive recommendations from Johns Hopkins about what they suggested should be done with Maya around this time?
But my understanding was they didn't want to release her to me. They wanted her to go somewhere else.
Do you know where they wanted?
I apologize, Mr. Harrison. Again, objection, and I believe this is starting to invade issues.
What issues?
Why don't you come forward? I'm going to sustain the objection.
Let's go down to the bottom of 001. I'm sorry. Yes. So you see the admissions diagnosis there?
Yes.
And what does it say the admission diagnosis was?
Fictitious disorder and conversion disorder.
And then over to the right?
over to the right where, I'm sorry.
Okay, take fact.
Oh, I'm sorry, Munchausen syndrome by proxy.
All right, so this is upon admission back when?
That was January 13th, 2017.
That says for the discharge, right?
Yes.
But the admission diagnosis.
Oh, the admission?
She was admitted when?
She was admitted October 7th.
So upon admission, October 7th, do you see anywhere that that a complex regional pain disorder was put down as a diagnosis?
Your Honor, it misstates the record. This is referred to the second admission.
This is a speaking objection again, and I'm just asking what's on the piece of paper.
He's
Are
asking
you,
Yes.
I'm going to sustain the objection.
Right. And so on the discharge diagnosis, what does it say that the discharge diagnosis was?
Where it's in, or it's highlighted?
Yes.
Discharge diagnosis, fictitious disorder, Munchausen syndrome by proxy, conversion disorder.
And is it the same as the admission diagnosis?
Yes.
And down there, do you see a secondary diagnosis?
Atopic dermatitis.
Do you know whether when Johns Hopkins did refer to your child's lesions, that was the way it was stated?
No.
I got it. Yeah. Well, this is. I got to find the page number. See. The 8th page of that exhibit, and that being the discharge summary at 1001. So that would be the 8th page. And it's JHACH 8511 on the bottom, if we've got that. All right. So I turn your attention to the documented medications.
Yes.
And is this Aquaphor, was that one of the topical lotions used to treat Maya's lesions?
We did not have that, I believe, in the past. That's what they discharged her with from Johns Hopkins.
All right. And acetaminophen was essentially Tylenol?
I believe so.
But let's go down to prescriptions now. I want you to count, upon discharge from Johns Hopkins, how many medications they had your daughter on.
1, 2. More than 3. I'm sorry. There's, I believe, more than 12 here. I didn't count all of them, but.
And that would be my question, is the amount that they list here as what they're discharging your daughter to take, more than 3.
That is correct.
And then look on the next page, 8512. Did they want a follow-up with Rebecca Johnson? I'm sorry, it's 008512.
Okay, I see it. Yeah. Follow up with Rebecca Johnson, yes.
And who is Rebecca Johnson?
Rebecca Johnson, she worked for Eagles Wings at the time. She's now down in Cape Coral.
And was Rebecca Johnson one of the 2 therapists that you and your family went to find some comfort from the psychological issues of this CRPS?
That is correct. And we ended up going down to Cape Coral to see her as well.
And then down to Agility Fitness, and we've heard from them.
That is correct.
And then Dr. John Wassenauer, the pediatrician.
Correct.
Okay. I want you to describe for the jury, when you finally did get Maya out of the hospital, what was her condition?
Number one, I had to pick her up alone. I wasn't able to bring my attorney with me, so I brought another person to help me. Maya was extremely weak. We put her in the back seat of the vehicle. We used all the stuffed animals she had from the hospital to help prop her up. She was very weak. Kind of remind me of a weeble. She was wobbling. If we made a turn or something, she would fall over. She didn't have the strength.
Was she in better or worse condition than when she checked in?
She was in worse condition, but you should have seen the smile on her face when we were driving over the Skyway Bridge.
A lot of relief from
Yes.
getting out of there. And was her condition to the point where you were worried whether she would survive much longer in Johns Hopkins?
Yes, I was worried.
And before she passed on, was that a concern of your wife, Beata, as well?
That is correct.
Now, since your wife died, since you took Maya out of the hospital, has she continued to exhibit signs, symptoms of CRPS
Yes,
on more than one occasion?
more than many occasions.
Does she have big relapses and small relapses?
Big and small, yes.
Describe the difference.
Some she'll lay in bed, she'll cry, or like today, she's stating her limbs are hurting, but she tolerates pain, she tries to keep going. She had one in November of 2020, I could be wrong, where she had to be hospitalized. She lost a lot of weight, and she looked very, very, very ill. She was within the hospital for a week. She had to have a feeding tube.
Does she worry sometimes about telling you how she's doing?
Yes, absolutely.
And why is that?
She don't want me to worry because, unfortunately, we cannot get that treatment to where we have an order not to.
Objection.
Sorry.
To strengthen this characterization of evidence. Yeah, and we probably do need to approach on this.
There.
Sorry.
Leaving aside that, did you have concerns of what would happen if Maya or you reported to a physician that you were using ketamine with another physician, say, to help her?
Yes.
And why is that?
number one, her new diagnosis, conversion disorder, fictitious disorder, and also just from the previous experience.
Did you have any concern that if it appeared in her records again, you would go through this again?
Yes.
Was that the main reason then that you held off taking her back for that?
Yes.
So did Maya have to simply rely on physical therapy?
Grin and bear it, yes. Physical therapy.
And tell the jury how hard she worked at that.
Maya was determined. I'm sure you heard from the physical therapist. She's not one to give up. She inherited that from her mother with many things. She was determined. She would do a lot of swimming. She was with Kyle. That she had a partner to make it more fun. And she was determined to get out of that wheelchair, get on crutches, and then eventually crutches to walking. And I'll never forget that day as well. Wonderful.
As we sit here today, does your daughter have CRPS lesions on her legs or ankles?
Yes, she does.
And tell the jury, throughout the time that you were with Beata, did she ever exhibit any mental health problems other than anxiety over the effect of CRPS and then later the Johns Hopkins issues?
No.
One moment, Your Honor. No. Subject to recall on damages, your witness.
Yes. Good afternoon, sir.
Good afternoon.
I know you've been up there a while, but I'm going to take you back a little bit. So,
No, my new spot.
yeah. Going back to July 3rd, 2015, just so this jury's clear, there was never a physical injury that started Maya's ordeal that put her in the wheelchair, correct?
Not on that date. Like I stated earlier, there was an injury when she was in gymnastics, but we cannot pinpoint it on that.
The jury saw the video of Maya riding her bike on July 3rd in the parade. It's your testimony that that night she had some type of a panic attack over something and immediately experienced global pain. Is that true?
Not true. She didn't have a panic attack. She had an asthma attack.
Okay. So,
And she had some previous to that.
so in terms of what happened that day, once Maya had an asthma attack, she immediately had pain everywhere, not just confined to one limb, correct?
Not right away. She had difficulty breathing and then chest pain, I believe it was, in that record. I could be wrong.
Before you brought her to All Children's Hospital, you applied for Social Security disability for Maya, true?
Objection. Yeah, that's not specific.
Okay, so I'll clarify it.
Approach, please.
To clarify the question, sir, after the July 3rd, 2015 incident, but before you brought Maya to All Children's on October 7th, 2016, you had applied for Social Security disability for her, true?
That's a better question, yes.
Okay. Let me talk to you a little bit more about her treatment and try to get the time frame right. You had said that, if I get the sequence of facts right here, that you went to first Sarasota Memorial Hospital after the July 3rd incident, correct?
I believe that's correct.
And then you went to All Children's Hospital, and I think you were telling the jury people threw up their hands and didn't know what was wrong with her, and this was back in July of 2015, correct?
There was a doctor's hospital prior to that.
Okay.
And she was transported.
Right. So the sequence of events, the July 3rd, 2015 incident, doctor's hospital in Sarasota, and because they're not a pediatric hospital, they sent her up to All Children's in July of 2015, correct?
Correct.
Okay. At that July 2015 admission, do you remember what the discharge summary said in terms of Maya's condition and what they were recommending?
No, I don't.
Okay. I'd like to show you what's in evidence joint exhibit 1008-0004. Okay, and on the last paragraph where it starts, the patient was seen. Do you remember, sir, on the second sentence, and this is from the first hospitalization where you said people threw up their hands in the air and said, we don't know what to do. In fact, that you had declined, or Beata had declined, a neurological and psychological examination back in July of 2015. Do you remember that?
No, I don't.
Do you remember in the next sentence that you had requested transfer to an outside hospital? That would be the Lurie's in Chicago. Is that true?
That is true, after she put her arms up in the air.
Well, do you remember that either you or Beata were adamant that there would need to be a PIC line, an IV line put in for the transfer?
I'm unaware of that.
Okay. Do you remember All Children's Hospital telling you that that PIC line would be inappropriate as both an infection and respiratory risk, and it was dangerous? Do you remember that?
Didn't you put one in?
In July of 2015, before you boarded a commercial airline to Chicago to go to Lurie's, do you recall asking for a PIC line then?
I do not.
Okay. Let me ask you about the records up in...
We're reading reports, hospital records now?
I'll ask you about the next one, sir.
Okay.
I actually won't show you this one because it's not in evidence, but let me see if I can understand your testimony. You did not go to Chicago to Lurie's from here, did you?
Beata did. I did not.
Okay. Were you aware when Maya and Beata returned that in Chicago that the discharge summary raised a concern for a psychiatric component to Maya's presentation?
Facts not in evidence. Lurie records are not in evidence.
Overruled. You can answer.
Am I aware of it? No.
Okay. Beata did not tell you when she returned from Chicago that Lurie's Children's Hospital back in July of 2015 raised the concern for a psychiatric component?
Not that I'm aware of.
Did Beata tell you that Lurie's recommended a therapeutic program that combined physical and psychological therapy?
We did that. That was Tampa General.
Okay. Let me ask you about the Tampa General. You were at that admission, correct?
Yes.
Okay.
One of them.
So I'll talk to you specifically about coming from Lurie's. Then you went to Tampa General from July 2015 until August 2015. Is that correct?
Somewhere in that area, yes.
You were aware then that at Tampa General on discharge, one of the discharge diagnoses from Tampa General was psychological factor affecting physical condition.
And that's when Beata received that call from the nurse practitioner, Bonnie Rice, and that's when she was upset about that.
Okay. And so we've asked about what you were aware of and what Beata was aware of. Is what you're telling me that you were both aware that when you left Tampa General, that Tampa General back in August of 2015 diagnosed psychological factors affecting Maya's physical condition?
I was not aware until I heard Beata tell me from that phone call with Bonnie Rice.
Were you aware in August, specifically August 27th, 2015, that Tampa General's recommendation was for intensive physical and cognitive therapy following discharge?
At Tampa General?
Correct. When you were,
I'm unaware of I know she got the PT, but I don't know if she received anything.
let me ask it this way, Mr. Kowalski. Is what you're telling me in terms of the specifics of what Maya's diagnosis was and the recommendations from Tampa General something that Beata would know and not you?
Beata knows a lot more than I do.
Okay.
You ask a lot of fathers, I'm sure they don't even know where their kid's pediatrician is.
Well, within a month of leaving Tampa General within those recommendations, you had established with Dr. Kirkpatrick in September, correct?
In September, yes.
Okay. And so while Tampa General recommended rehabilitation with cognitive and physical therapy, and incidentally, they did not recommend ketamine, did they?
Who's that, Tampa General? She didn't get better in Tampa General, just the upper body.
Tampa General did not recommend to you when you left Tampa General that you start ketamine, did they?
No.
And yet a month later, despite their recommendations, respectfully, you were at Dr. Kirkpatrick's office getting treatment for ketamine, true?
We went to Dr. Kirkpatrick, after that, but we still did physical therapy on that, and she went to Eagle Swings.
Okay. You agree, do you not, that there is a psychological component to Maya's condition?
If anybody has any type of injury, there's some sort of psychological effect.
You have heard many times, and you've personally seen, that when Maya's with you, she's completely normal, and that when Beata walked in the room, she's in pain.
That's false. There's times she did it for me as well. That's false.
I need to approach on this issue, Your Honor.
Okay, you may continue, Mr. Shapiro.
Thank you. With the court's permission, I'd like to play clip 6 from an interview that Mr. Kowalski gave with Detective Graham.
I was told here at the hospital upon her admission, and maybe some of this will shine a light on at home too. When nobody else was in the room but Maya and the staff, she acted completely normal. When Mom would walk in the room, she was instantly in pain.
I've heard that many times.
There's no other explanation
Well,
for that.
Yeah, I noticed it too with myself being home, and then Mom comes home from work.
And all of a sudden she's bad.
There'll be changes, yes.
So you're at home, your guys are doing well, playing.
No complaints about pain.
No complaints about
But then
pain.
when Mom gets home,
She's in
maybe-
pain.
Mr. Kowalski, do you recall that interview was with Detective Graham on November 17th, 2016?
I do.
Okay. And everything you said to Detective Graham that day was true, correct?
That is true. And then after reviewing medical records in your hospital notes, it states that she did the same thing for me.
In terms of the timeline, did you go to Mexico when Maya was being put into the coma?
We addressed that earlier. I went to my oldest daughter's wedding, and then from there I took my son back to Florida, and then I proceeded back to Mexico.
Were you aware that the risk of death from that coma was 50%?
There's a risk in every procedure.
Well, I understand that, Mr. Kowalski, but respectfully, there's a risk, and then there's a risk that's a coin flip whether your daughter would unfortunately pass. Did you know that the risk of death in Mexico was 50%?
They stated there was a 50% risk, but they also told us nobody ever died from that procedure.
Are you aware of what complications Maya suffered while she was under her coma in Mexico?
We were informed.
Okay. Your wife blogged about those, did she not?
She had a blog.
Okay. And part of her blog was, you've seen the blogs, true?
No, I have not.
Okay. You're aware that your wife was blogging about Maya's care while Maya was in the coma. Is that true?
Yes.
Okay.
I don't know if you ever had a sick person in your family, everybody calling you, and you're repeating the same story over and over. This was a way of communicating to everybody at once.
After you got back from Mexico, you or Beata took Maya to a Dr. Elvin Mendez. Do you recall that?
I do not recall that, but that name does sound really familiar.
Okay. Are you aware?
Objections, not in evidence.
I'm not publishing it.
Well,
You can continue.
Are you aware that Dr. Mendez on December 10th, 2015, noted in his record that consideration may be given to possible Munchausen's by proxy?
I heard of that after time.
Okay. My question to you is, did Beata tell you that Dr. Mendez wrote in his record as of December 10th, 2015, that consideration must be given to possible Munchausen by proxy? Were you aware of it then?
Not at that time, it was later on.
Okay. You were, your wife kept notes of Maya's treatment,
She did.
and you were kind enough to turn over. Would you be able to identify her handwriting, Beatas?
I hope so.
Okay. This is not in evidence, but I'm going to ask, I can hand Mr. Kowalski a copy, or we can put it on the screen, whichever you prefer.
Well, if you've got the paper copies, let's use that, but make sure Mr. Anderson sees what you're going to show him first.
we need to approach the court's prior has already ruled on this.
You may proceed, Mr. Shapiro.
May I approach, Your Honor?
You may.
The record will reflect that I've handed Mr. Kowalski what we previously marked as Defense Exhibit 3239-0080. Mr. Kowalski, I'll represent to you as well. This was produced by you to my office in response to a request on September 16th, 2019. My question to you is, do you see in the top right corner some handwriting on this document?
You mean top left?
I apologize, sir. Yes, top left.
Yes, I do.
And is that your wife's handwriting?
It appears to be.
Are you able to read what she wrote?
Looks like Sunday, Monday. Yeah, I could read some of it.
And let me ask you if this is what it says. Sunday, 10/2, Maya hurt her foot in BRP. Is that right?
BRP? Yes.
Okay. And then it says Monday, 10/3, Ket IV, 0 availability in office, or it says 0 availability in office, Ket IV out of desperation. Is that what it says?
That's what it. What was that? Oh, unbearable. Okay, yes.
And it says Ket IV out of desperation, pain was unbearable. Is that right?
Yes.
Okay. I can leave the document with him or I can take it back at your preference, Your Honor. Those are the only questions on this. You don't recall whether Maya had any skin lesions when she left Tampa General, do you?
No, I don't.
And you don't recall whether she had any skin lesions when she presented to Dr. Kirkpatrick, do you?
That I do not know. That would be in his medical records.
Okay. Maya had not walked from the time of her incident on July 3rd, 2015, until after her discharge from All Children's Hospital in, I think it was August of 2017. Is that right? Sorry. Let me.
Objection.
Yeah, it was a confusing question, so let me just rephrase. From the time of Maya's incident on July 3rd, 2015, through when you brought her to All Children's Hospital on October 7th, 2016, she had not walked in that period of time. Is that true?
Objection. Misstates the timetable.
I believe she may have walked when she came home. She was weak. She was carried in. She walked a day or so, and then after that, no.
Okay. I wanted to talk to you a little bit about what you described as a relapse in August of 2016. Okay. And
Okay.
this was about the homebound school
Correct.
program. I just want to make sure I understand what you told the jury yesterday. Maya was asked to come to school for an evaluation in 2016. Is that right?
No, that's wrong.
You brought her to school in August 2016,
Yes.
and after being there, Taylor Ranch School said that she had to come back in full-time and canceled homebound. Is that right?
Real quick, there was a fundraiser for her, the lemonade stand. So she went to that. She was sitting in the library. The person in charge of the homebound seen her in there with the kids, and after that she was denied homebound.
Okay. After someone from the school observed her at the school at the lemonade stand, they then denied Maya's continued homebound. Is that right?
That is correct, and then we had to hire Jane Wisner.
Okay. You hired a lawyer to appeal that decision. And the jury's already seen the letters from Dr. Wassenauer, and there may be one from Dr. Hanna they'll see as well. But the point being, Mr. Kowalski, there was no physical injury at that time, was there?
Object to the long predicates in these questions.
I'll re-ask the
Just
question.
ask questions.
When Maya had her relapse in August of 2016, there was no physical injury at that time. Is that true?
No physical, it was caused from stress.
Let me talk to you a little bit about the decision to go to All Children's. You were already up in Tampa on October 6th getting an infusion with Dr. Hannah, correct?
No, Clearwater.
I apologize. You were staying at the Ronald McDonald House attached to All Children's Hospital, correct?
That is correct.
You were already up in St. Pete, Clearwater, getting treatments with Dr. Hannah on October 6th.
Yes, she was with Beata and I relieved Beata.
The plan was, had she not been admitted to All Children's, she was scheduled for another infusion with Dr. Hannah on October 7th, correct?
That is correct.
You didn't come up here because of a hurricane, did you?
No, she was getting treatment.
Okay. Just if there was any argument earlier in this tribunal or elsewhere that the reason why you were up or brought Maya up to this area from a hurricane or fear of a hurricane, that's not true. It was solely because she was already here getting treatment with Dr. Hannah, correct?
We were here,
Okay.
or in St. Pete, I should say. In St. Pete. We were here in St. Pete.
Dr. Hannah referred you to All Children's Hospital, correct?
No. I was with Maya, and she was in severe pain. I decided to take her there. I knew she had a treatment the following day, but I knew her pain. And you were the closest facility, and that's what I chose.
When you arrived at All Children's Hospital, were you the parent that signed consent for All Children's?
I was the parent that brought her in.
Did you ever, in writing, revoke consent for treatment?
I didn't know I had that opportunity.
Let me ask you about some of the statements or records upon arrival at All Children's. This is Joint Exhibit 1001-18. And as a predicate, sir, were both you and Beata at the hospital at this point?
Beata arrived approximately an hour later. That sounds about right. It takes about an hour from Venice to get to St. Pete. 9:45, I believe she was there.
So by 9:50, the first note, it says an ultrasound was canceled because mother insists she will not tolerate it unless she has, meaning Maya, 1,500 milligrams of ketamine, which I am unable to give in the ED. Were you there when that discussion went on?
I was there, but I believe that's incorrect. She was in severe pain. She had her knees up to her chest. That's why the ultrasound was refused at that time. I didn't understand how you're going to take an ultrasound when she's that much in pain.
Beata was asking for 1,500 milligrams of ketamine, true?
She asked for ketamine. I cannot say true on the amount that you have here.
Okay.
She did ask for ketamine.
And
you did give.
Let me ask you about Joint Exhibit 1001-3118. But before we go there, do you know the dose of ketamine that All Children's gave?
Of All Children's?
Correct. How
No,
much?
I do not.
Okay. Do you know whether it was dramatically less than what Dr. Hannah had given the day before?
That I'm not a doctor, and I don't know everybody's procedures.
Joint Exhibit 1001-3118. Do you recall at the top, this is also on the day of admission, that mom, meaning Beata, insisted that patient, being Maya, was in severe pain and needs to have more propofol. Were you there for that conversation?
I was there, but I don't recall. I know she asked for the ketamine.
You do know that propofol is a general anesthetic, do you not?
I do not know that.
Okay. Let me ask you about Joint Exhibit 1001-0081. Let me ask you, this is also on the day of admission. Let me ask you if you recall this event. In the middle of the paragraph, the language that starts with, I was speaking to mother. I wanted to ask you about the second sentence. She, which would be Maya, had been attempting to take off all of her monitors. I, being doctor...
Objection to reading medical records. Sauce for the goose.
Sure. I'll have you read the highlighted portion, and my question to you, sir, will be that this sentence and the next one, if you could highlight it as well, all the way through the word staff. My question to you, sir, is, were you there for this event?
I was there, but you have to, I think there's a big key missing out of this, and it was the blood pressure cuff. The blood pressure cuff was a big issue and causing pain. That she did get agitated, yes, you're right, but there was a component that caused that thrashing.
Okay. Let me ask you about Joint Exhibit 1001-3117, and I'll represent to you this is on the next day, October 8th. Were you there at All Children's Hospital?
Does it say if I was or not? I undetermined if I was there or not.
Okay, and that's part of the reason I'm asking these questions. If you were a witness to some of this treatment, if you knew whether you were there at All Children's on October 8th or not, do you know?
I do not know.
Okay. Do you have any knowledge of the bottom quote where it says 10/8/2016 about mom insisting the propofol not working? Any knowledge of this event?
I do not have knowledge on that. Sorry.
Okay. And again, well, let me ask you about the next exhibit. This would be earlier in the day on October 8th. Joint Exhibit 1001-2721. And it's the second result specifically I wanted to ask you about because it was in the middle of the day. And you had mentioned earlier that Maya refused to have her blood pressure taken. That's true, correct?
Yes, that's true.
Okay. Do you remember Maya telling the staff, quote, "I'll do it if you sedate me"?
Do you realize the pain of CRPS? This little girl knows her pain. She knows what she could tolerate. She needs something for her pain to get a blood pressure. It sounds so goofy to us, but for her, she's in extreme pain and she needs something for that pain before she could tolerate a blood pressure cuff.
But is this a true statement?
If I said that, I'd be speculating, right? I mean,
let me ask you about Joint Exhibit 1001-639. And I'll represent to you that this is an anesthesiology note taken on 10/8/2016 under the part anesthesiology note, and I'll ask you to read the part where it starts the second under additional comments. Family has insisted upon intubation with medically induced coma.
Okay.
Okay. Do you remember? It says, which I stated to the father, is not an option because we have Maya.
Objection, reading.
All right, I'll stop. I'll let you read this, Mr. Kowalski.
I want to stop you there for a second. We told the story of Maya's history in the triage and in the emergency room. I don't know where they came up with medical-induced coma. We knew we could not get a medical-induced coma in the United States. We're fully aware of that. So wherever this came from, I don't know. That is incorrect in your records there.
Okay. So in terms of what they've documented here upon your request on that day for a medically induced coma, you dispute it?
I don't agree with that.
Let me ask you about what's in the record at 1001-2711. And in the middle of the page, this is now on October 12th. Were you aware of these statements from Maya that she wanted to go to heaven?
She was in extreme pain. You ask any CRPS person in extreme pain, a lot of them, as we told you before, this is a suicide disease. A lot of them want to go. They cannot tolerate the pain.
Well, I'll ask you about that in a moment, but the next line says, Mom also states, I don't care how much medicine or side effects. I want her comfortable and out of pain. Is that something you believe your wife would have said?
I cannot answer for that.
Okay. Let me ask you about Joint Exhibit 1001-2719. It's the text result in the middle of the page, text 8851, other during CT scan. If you'll take a moment to read that, sir.
I cannot answer for that.
Okay. You can't tell the jury whether or not this is true, whether Beata had told Maya she would get a reward of Valium if she laid still for a CT scan.
Objection, Your Honor. This is triple hearsay, and we've objected to this before.
What was your question?
Can you tell the jury one way or the other whether Beata was using Valium as a reward for Maya?
At home?
At asking for this at the hospital.
Oh, at the hospital? I wasn't there. I cannot answer for that. But at home, absolutely not.
Okay. Lower down the page, T892, says there was a family meeting. I'll let you read it. It says in family meeting, mother stated. I'll let you read it. Let me know when you're done, sir.
I read it.
Do you recall being part of a family meeting where this was stated?
I don't remember this being stated, but yes, I was in a family meeting. You are correct on that. Consult hospice. We were very concerned of losing our daughter.
Mm-hmm. Do you remember the request for consultation for hospice?
I don't recall that. I'm sorry.
Okay.
And I'm not, just there, when you're in that situation, you're very, very overwhelmed. So much going on. I do not recall a lot of that, and I apologize.
Let me ask you next about, we talked a little bit earlier about consent, or what you've told this jury is your lack of consent to stay at All Children's. Okay, so I want to frame for you the time period so it's clear for this jury. You brought Maya to All Children's on the morning of October 7th, 2016, correct?
Yes.
You're aware that by 2:30 in the morning on October 13th, 2016, so a little less than a week later, the state of Florida took custody of Maya, correct?
I wasn't aware at 2:30 in the morning. It was later on the 13th.
I apologize. In fairness to you, you probably found out later that day.
Yes, unfortunately in a bad way.
Okay. The claim that you're making for this jury for false imprisonment, you understand, is from between October 7th and October 13th.
I do now.
Okay. Let me ask you about Joint Exhibit 100154. Okay. Actually, let me instead ask you about 1001-630. I'll represent to you, this is a pain management note by a doctor named Dr. Jenny Dolan, and this is on October 9th, so the third day that you're there, and I'm going to ask you to read at the bottom, not the bottom, but about halfway down where it says, today, Dr. Dolan, Dr. Tepa Sanchez, and specifically the last part where it says, today is day 3 of ketamine and Precedex infusion, and all the way through the end. And let me know when you've finished reading it, sir.
Got it.
This record reflects that you and Beata agreed with this plan of care, true?
We had no choice.
Sir, you agreed with the plan of care being offered by the hospital, true?
We had two choices.
Well, let me ask you about the next record, sir. This is Joint Exhibit 1001-620. Actually, let me ask you about 1001-620, yes. This is a pain management note now on October 11th, 2 days before DCF took custody.
Okay.
Do you remember? And I'm going to ask you about the part where it says anesthesiology note. Take a moment to read it, please, sir.
Okay.
The note is accurate. You would agree that you had a chance to discuss the plan of care with Dr. Elliott from the pain management team. Your questions were answered and you understood and verbalized this plan of care, true?
I do remember talking to Dr. Elliott, but I don't recall what was discussed at that time. So I cannot say yes or no on that. I'm sorry.
You're not disputing what this note says, are you?
And I'm not saying that it's true.
Okay. Well, let me ask you about Joint Exhibit 1001-2026. And just the first sentence at the top, where it says actions taken.
Mm-hmm.
You can go ahead and read the first sentence. And for frame of reference, I'll represent to you, this is October 11th.
Okay.
And if you want to highlight it, Clay, SW contacted by medical team. Parents have agreed to stay. That's true as of that date, is it not, sir?
At that time.
Okay. Let me ask you about Joint Exhibit 1001/76.
What about the concern that mother was going to change her mind?
Right. Let's talk about that.
Let's do it.
On October 11th, 2016, you and Mrs. Kowalski at that moment agreed to stay at All Children's.
We had no choice.
Sir, there's nowhere in this record anywhere that says the parents are asking to go home.
Isn't that funny?
You noted in the record, you're not disputing that you told the medical team at All Children's that you were agreeing to stay. The concern was that Beata might change her mind, but you were agreeing to stay as of October 11th, true?
Remember that meeting we had? We were told if we left, we'd be arrested.
Let's talk about that. I'm going to show you what's in evidence as Trial Exhibit 2408-1739. Uh, 2408-1739. Do you have that? Let's go to 1738 first, just so we can lay the predicate. This is an email that Beata, your wife, wrote to herself and copied you on October 12th, 2016 at 9:27 p.m. Do you see that?
Yes.
Okay, and just for verification, at the top, that is her email address, correct?
Yes, it is.
On the second page, let's go to 2408-1739.
Is this in evidence?
You moved it in, I thought they moved it in today.
Is this in evidence?
You put it in evidence this morning, sir.
Which one?
That's a double page.
Let me see.
The clerk says this one's in evidence.
Is or is not?
I'm sorry?
Is.
Is.
Okay, Clay, you can put it back up, 2408-1739.
Okay.
Let's talk about halfway down the page. It says Tuesday, 10/11, late afternoon. The same woman from CPS. Incidentally, that's Sally Smith, correct?
I do not know.
Okay. Well, let me ask you about this. She received a complaint that we wanted to take Maya, AMA, that's against medical advice, and take her home. That's a lie. That's what Beata wrote. True?
Not at first. She wanted to go to Nemours.
Sir.
Or she wanted to go to Dr. Hannah for treatment.
On Tuesday, October 11th, 2 days before the state took custody of your daughter, your wife sent you an email and copied herself that specifically said that she was disclaiming, she was disputing the allegation that you and her wanted to take Maya out of the hospital.
And to take her home. She wasn't going to take her home.
She was not, she agreed to stay at All Children's Hospital as of October 11th. She was disputing the allegation in an email to you that she was trying to leave against medical advice. That's what this says, does it not?
That's your interpretation.
Okay. Let me ask you about Joint Exhibit 1001-73. This is the next day, on October 12th.
Okay.
Under the interim history at the top, I'm going to ask you to read where it says they reviewed all of the patient's medical records to the, that's fine, you can leave it there, but what I'm focusing you on is halfway down where it says they reviewed until the end of the paragraph.
Who is they, first of all? I'm sorry.
They is you. At the end it says, this was discussed with the mother who's in agreement with the plan.
Objection, again, reading the record.
This, I'll back up. It says, this was discussed with the mother. The mother agreed to proceed and the patient will require go lightly clean out. At the end it says, this was discussed with the mother who is in agreement with the plan of care. Isn't that true?
Yes and no. We were told if we left, we would be arrested. So we had to follow your guide.
You can't tell this jury who told you were going to get arrested, true?
No, it was in the meeting, and it was somebody within that meeting, one of your staff.
After All Children's, well, let me ask you this. You were asked some questions about visitation. After Maya was taken into custody by the state of Florida, you understood, sir, visitation at All Children's could only happen pursuant to DCF approval, true?
It had to be supervised is what we were told.
On October 16th, 2016, you specifically responded to a request to DCF where they asked you, who do you want on your approved visitor list? True?
There was a list for supervisors, and then there was nothing in reference to like the priest and things like that. No.
I'll ask you about the priest in a moment. But do you recall, sir, that on October 16th, 2016, you wrote a letter to the child protective investigator with the state of Florida? Her name was Lindsay Massica.
Yes, I do remember that. Social security numbers on there?
Yes.
Yes.
Because DCF required all visitors to go into All Children's Hospital to undergo a background check, correct?
Correct.
And they asked you, can you please provide us, meaning DCF, with a list of people that you would like to visit Maya?
Yes.
And then DCF was going to run background checks, correct?
That's what they were supposed to do. And then my brother, Bob Reines, he called. And
Well-
they said the hospital will not allow him because he's a family member. The hospital will not allow it.
But you don't know, as you sit here today, whether that denial was because DCF had not approved him versus All Children's not getting word from DCF whether he'd been approved, do you?
This is hearsay, but he could contest to it. He has a letter, and he also spoke with her, and they said the hospital is controlling this, and they should not be doing it.
All of those decisions on who could come and go at the hospital after October 13th to your understanding, was under the jurisdiction of DCF approval, true?
I just told you it wasn't.
Well, let me ask you about, this is not in evidence yet, but I would ask Clay if you can show him only.
Well, no.
Sorry. Well, let me ask you a question first. Let me lay the prayer. Do you remember that on October 27th, 2016, you wrote a letter complaining about the church people coming to Maya's room who gained access to her room without your approval?
Not without my approval. What happened is, I believe it was Tori Nellis. She
was with
stated that there was some visitors, not only the church people, but there was somebody else that came in and gave a gift to my child, and then also the young lady that runs the Ronald McDonald House. She said, if these people come in anymore, I'm going to lose my visitation privileges. I was highly concerned, and I did not know about the church people. I had nothing to do with that. So yes, I did write a letter to my lawyer, Deborah Salisbury.
Because you were working with Tony Niehaus, was with who?
Tori,
Tori was with who, sir?
one of the third party, whatever, Safe Coalition or whatever, I don't know.
With the DCF Safe Coalition group, true?
Somebody like that.
And your complaint was that you didn't understand how they were able to access Maya's room without your permission, true?
I was concerned not only for them, but the other people that went in there as well.
You
I
did-
did not want to lose my privileges.
You didn't authorize them to come to Maya's room either, did you, sir?
I don't have that authority.
Let me ask you about, you were asked by your counsel about some transfer diagnoses, okay?
Yes.
You're not denying to this jury that as of November, after Maya was sheltered by order of the state, in early November, you and your wife had the opportunity to consent for Maya being transferred out of All Children's Hospital, but you and Beata refused.
That is correct.
Let me ask you about one of the other documents on that issue as well. Well,
And that wasn't you and Beata. Beata refused. I remember that.
okay. But just so this is clear, in November, Maya could have left All Children's if Beata had said yes.
She could have, but we weren't going to do it under that diagnosis.
The diagnosis code that had already been made at Lurie Children's, Tampa General, and at Dr. Menda's office, true?
Objection, those are facts not in evidence, misstates the evidence, and if we're going
Sustained.
to have him comment on it.
Sustained. And Mr. Shapiro, the jury's been seated for over an hour and 30 minutes.
Now's a good time for a break, sir.
Now's a good time. Now, members of the jury, this is going to be your last break of the day, hopefully. Let's try to keep this to 10 minutes. Let's do not discuss this case amongst yourselves. Do not do any investigation. Receive no information.
All rise. There is exit.
Jury's out of our presence. Let's talk scheduling for just a moment.
I have a motion, Your Honor.
Let's talk. What's your motion?
Judge, we objected and we're moving for a curative instruction because nowhere in those records does it say Munchausen by proxy. All it says is conversion disorder. It simply means that they believed that Maya believed, but there was that there was pain, but there was no organic. There's a huge difference between Munchausen by proxy, which is a criminal act, and conversion disorder. And if they can show me in any of those records where it actually says Munchausen by proxy as diagnosis, let's see it.
If I can approach
He said it was Lurie's and...
What am I looking at? Lee Memorial?
This is a record from Dr. Menda's.
That's not TGH, that's not Lurie, that's not a diagnosis. It's not a diagnosis. It's a...
Do you have a document from either TGH or Lurie's that says Munchausen by
I
proxy.
believe my question was conversion order or Munchausen by proxy.
Okay. Answer the question. Do you have a document from Lurie's or Tampa General that says Munchausen by proxy?
Not Munchausen, but conversion disorder. Factitious disorder.
No, it's not practice.
Factitious disorder.
Folks,
Sorry.
what I would recommend is get some language, and then we'll talk about it. But, you know, I am going to need to see whatever record or records are from Lurie's and Tampa General that underlie the question. So
Can we have the question read back so that we can craft instruction? Let's request you, Ron.
I really want to go to the restroom myself. So yes, you can go. And I don't know.
It was the last question. Cross-examination.
Perhaps after everyone uses the restroom, the court reporter would be so kind to help you all out with that particular question.
Thank you.
Let's talk schedule for a moment. Mr. Shapiro, how much, I know you said an hour, but I know Mr. Anderson said that direct was only going to be an hour, so.
30 to 45 minutes.
Okay, which puts us to 4:15-ish. Do we have a witness or a deposition that's an hour or less?
I don't know.
That's ready to go.
Looking at it, it's more than an hour, 35, 45, I think.
It's an hour 20. Our depositions are over an hour.
My question is there a deposition that is ready to play that is 1 hour or less?
No, Your Honor.
So effectively, we're going to finish with this witness and then have no other witnesses today, it sounds like.
Sounds like.
Okay, let's take less than 10 minutes for a break.
There's email that is being printed.
Well, Mr. Hughes,
All right, everyone quit on me. I'm trying this one solo.
there you go. Come on down.
No, I don't. I think people are probably still going to be there.
That it's already been made at Lurie Children's, Tampa General, and at Dr. Mendez's office. True, and we have the objection.
Wasn't a reference to
It was a reference to Munchausen. That's what Dr. Mendez's records get used for.
My implication from the question was 3 prior institutions had already put in their records that there was a psychiatric diagnosis to this illness, with the implication being that the plaintiff's point in this case is we weren't going to agree to any transfer that contains something referencing a psychiatric diagnosis. The rebuttal is it's already in the records. We weren't the first ones to put it in there. You're signing this doesn't indicate that there's anything new. That was the intent of the question, Your Honor. But I didn't specifically say Munchausen by proxy is in all 3 of the records.
Remind me, the Lee Memorial,
Is Munchausen.
was Maya an inpatient there?
She went to see her allergist, and during the appointment, he said suspicion for Munchausen's needs to be considered.
And that's the difference.
He's also a pediatrician as well. Allergist, immunologist, pediatrician.
The Lee Memorial doesn't seem like an admission then.
Well, I don't think I represented it was an admission.
The problem is, Your Honor, the term diagnosis. There is a huge difference between a doctor saying consideration must be given or thoughts may be carried. There are 7 different theories that they were trying to figure out. The question as posed puts it as a certainty that Lurie's, Tampa General, and then Menendez here all diagnosed Maya with Munchausen by proxy. Now, leaving aside for a moment the question of whether anybody there was qualified to do so and whether there's a report in saying that, which there isn't, by any psychologist or any psychiatrist. The fact is that what they're trying to do is get in something through the back door that they cannot get in through the front door because they don't have a single expert that says that Maya Kowalski had Munchausen by proxy because they gave up their CME, and without that, no psychologist or psychiatrist is going to get up there and say that. So right now we're in a situation where the jury thinks that this is an ongoing diagnosis. And so we ask the court to instruct the jury that until shown otherwise in the record of a diagnosis, that there is no diagnosis of Munchausen by proxy at any time, diagnosis of Munchausen by proxy at any time before October 7th stay at Johns Hopkins. And that is the truth.
The question that the court reporter read did not reference Munchausen by proxy.
But, Your Honor, in the lead up to that question, he had presented the Lee Memorial Health record and Dr. Mendez's record, and the only suspicion in there was Munchausen by proxy. So the question built in that lead up of the Lee Memorial record and Munchausen by proxy, and that was the insinuation.
And not only that, Judge, it is very important to consider here that no one diagnosed conversion before this. There wasn't a psychologist or psychiatrist that went in and said, I've done a differential diagnosis and this child definitely has conversion. What all of them say is the same thing. Consideration must be given. One of the thoughts is possibilities. It's all like that. And so what the defense has here now is an inability to get that before the jury directly. And the unavoidable conclusion of the jury from listening to the first question and then this one following up is, and it's a technique, I know it, but it confuses and conflates the issues between conversion and Munchausen by proxy, and that is simply not fair and it's simply not the truth.
Anything else from the defense?
Two things, Judge. First of all, Tampa General did in fact say diagnose
Let's hear it.
psychological factor affecting physical condition, conversion disorder versus factitious disorder versus other. The folks at Lurie's said something similar about a psychogenic disorder. He didn't say Munchausen by proxy. What I suggest we do is to say that the last question should be disregarded and let's start over. And let's be more clear. That's what needs to happen.
No, this point needs to be made because it's going to come up over and over and over again in this trial. And that is that they do not have, and the court just heard, there's a lot of dancing around that, but nobody diagnoses it. Show me where a doctor says after interviewing Maya and after consideration of the record, we have determined, a psychologist or psychiatrist has determined that Maya Kowalski is a diagnosed conversion disorder or a factitious disorder or a Munchausen by proxy. It's not there.
Well, the only thing I would respond to that is if we're saying in this courtroom that only a psychiatrist or psychologist can make this diagnosis, then they had Dr. Chopra come in as pain management and refute the diagnosis. But that aside, it's right here on the Tampa General discharge paperwork done by Dr. Paul Kornberg, who is a pediatric physiatrist.
Let me see that, please.
Physiatrist is your first clue.
It certainly wasn't when you crossed the where it was.
3047-0010. I am not inclined at this time to interject myself based on that last question. So I'm going to overrule your request for any sort of instruction with respect to that last question. I certainly don't want the defense to create an impression, though, that the records don't bear out. So let's just be very cognizant.
Yes, Your Honor.
Well,
Okay.
add that to the motion. We're going to get into it, and I think the court should enter some form of direction to counsel or order about this. Until they can show it, they shouldn't be coming in here and trying to mislead the jury over this. And that's exactly what's going on.
Anything else?
Not from the defense, Your Honor.
I understand.
Let's bring in the jury.
Can we make sure that this is in the record?
I'll write on it and hand it to the clerk. Okay, everyone, please be seated. Members of the jury, I want to confirm while you're away, you did not discuss this case amongst yourselves. You did no investigation and received no information. Is that all correct?
Correct.
And that no one approached you about this case. Is that correct?
Correct.
And you didn't see any media coverage?
No.
Okay, correct. Mr. Spear, you may continue.
Mr. Kowalski, just going back to the decision to stay at All Children's back on October 11th, so 2 days before shelter, you do admit there was a meeting with the doctors where Beata wanted to take Maya out, but you said, hold on, time out, and you asked the doctors, what time frame are you talking about? And when they explained, you said that's doable. And your wife wasn't happy with what you said, but you were upset that the hospital didn't write that down. Is that true?
Objection, compound question, multiple.
Sustained.
Okay, let me break it down. You agree there was a meeting with the folks at All Children's and you and Beata on October 11th, correct?
Yes.
And you agree during that meeting, Beata suggested taking Maya out of the hospital, but you said, hold on, time out. True?
True. And because we had no choice. They gave us, we're going to be arrested.
Okay.
So it's like, calm down, Beata. We have to do something here. So
Well, that's not what you said. What you said when the hospital told you on October 11th what the plan was, you told them that's doable. True?
we had no choice to be.
Your Honor, if I may approach.
You may.
Mr. Kowalski, to clarify,
Yes.
again, on October 11th, you were at a meeting where the doctors told you the time frame of how long they wanted Maya to stay, correct?
I don't know the time frame.
Well, you told the doctors, after they told you on October 11th, they wanted to keep Maya, you said that's doable, correct?
There was some argument there, so.
Well, you were upset when you found out that that conversation with you giving consent on October 11th to stay was not documented in the record, true?
I'm getting confused here now. Say that question again, please.
After you gave your consent at this meeting for Maya to stay at All Children's on October 11th, when All Children's told you the plan of how long they wanted there, and you said that's doable, when you found out that that conversation of you giving consent wasn't in the record, you were upset by that, true?
Objection, compound.
Overruled.
Big.
I was upset or Beata upset? I didn't understand what.
The conversation where you gave consent to stay on October 11th, you were upset that that conversation of your consent wasn't recorded in the record on October 11th, true?
I don't know if it was the consent. What was I talking about earlier? That was not, it was about being arrested. That was not in the report. That's what I said before.
Your Honor, I'd like to play for impeachment, clip 1 of the audio.
When I replied to her,
At this time.
Okay.
it
Well,
was in reference to being arrested.
Sir, there was nothing, let me ask you this. Do you remember when you sat down for an interview with Detective Graham?
I do not, oh, Detective Graham, yes, I do.
On that interview with Detective Graham was on November 17th, 2016, correct?
I would have to look at the date, but somewhere in that area.
I'll represent to you.
Okay.
It was, and Detective Graham was one of the investigators with Sarasota County, correct?
I'm aware of her.
Okay. Do you recall having a conversation with Detective Graham where she asked you about whether you were supportive of keeping Maya at the hospital?
I would have to see that, but there was something, I'm supportive of getting Maya better, I remember, yes.
Okay. Well, did you not tell Detective Graham that you were at a meeting with the doctors one day and Beata wanted to take Maya out, sign her out, and you said, hold on, time out?
Objection. Just reading in the.
Sustained.
Okay. Do you remember telling Detective Graham that you were in support of Maya staying at the hospital as of October?
Same thing.
They overruled on that one.
Yeah, I'm unaware of that, to be honest with you, but I know things were talked about, but I do not recall that part.
Well, let me just ask you this while the jury's here. Are you disputing that you gave consent for Maya to stay in the hospital on October 11th after having a conversation with the medical doctors where you told them that's doable? Are you disputing that?
Like I said, sir, that we were under certain things we had to follow, I do not recall that part.
Okay. You're not disputing, are you, that on October 11th that you gave consent for Maya
I'm
to
not
stay?
saying yes or no.
Objection. Let's ask and answer the third time.
You can finish, Mr. Kowalski, your answer.
Yeah, that, I'm unaware right now. I'm sorry.
Well, even as of November 17th, 2016, you were receptive to keeping Maya at All Children's. True?
She was under state custody at that time, and then we refused the transport because of the coding.
Wasn't my question to you, sir. Even after state custody, on November 17th, 2016, you were receptive to keeping Maya at All Children's Hospital.
Do you
True?
have something to show me to help back that up? I don't know where you're going with this.
Okay, I'd be happy to play that
Yeah,
for
please.
you, sir. Clip 4, please. Well, sorry.
Wait a second. Are you asked, is this for refreshing the recollection? 'Cause if so, just show him the transcript.
Which depot was this from?
This is, I didn't ask for my apologies.
There's 5 depots, so which
No,
one?
this is from your interview with Detective.
Oh,
Graham.
okay. That's what it says there.
Well, I understand that's what it says, sir. It's true, though, is it not?
Well, I can't, it's there, so.
Respectfully, Mr. Kowalski, you told Detective Graham while Maya was sheltered at All Children's Hospital that you were receptive to keeping there even as of November, true?
That's what it says, but that interview was extremely, very, very difficult to get through. She was, you heard the tape.
Did you didn't lie?
Let him finish, please.
Sorry, go ahead, sir.
I was under a lot of stress. I didn't know where she was going with that. You know, but I do not recall that, but that's what's in the writing. I must have said it, yes.
Okay. So what's clear to this jury, admit that you told Detective Graham on November 17th, 2016, that you were receptive, even at that point, to keeping my adult children. You're not disputing that, are you?
I'm not
That's
disputing.
irrelevant. The
On-
decision already been made. I move to strike.
Overruled.
Let me ask you about some of the bills that you were asked about.
Yes,
When did you first review the bills from All Children's?
the bills would have been after Beata's death, I would imagine,
Okay.
because she's the one that handled the bills.
So just to be clear, the bills that you reviewed from All Children's that your counsel walked you through, you would have reviewed after your wife's death, true?
Yes, I didn't, it was, I had no idea where she kept all that, and it took some time.
Okay. At the time you reviewed them, did you believe the CRPS codes were true and accurate?
On the billing,
Yes.
it's state CRPS on there.
Let me ask you a little bit more about that. And Clay, it's Joint Exhibit 2017-663. You might be able to enlarge it for us.
Thank you.
Okay. This bill that you were shown, you see that the services rendered included for endoscopy, true?
Yes,
They included for nutrition.
yes,
There are, by my count, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12 diagnoses codes that were submitted as part of this bill. True?
yes,
Among those were CRPS and child neglect or abandonment, among others. True?
I see that.
Sir, can you tell this jury what percentage of the $5,980 was paid for CRPS?
I don't see where the percentage would be.
Well, it doesn't say it.
Okay.
And I'm not trying to trap you, but the allegation that All Children's billed
Was given to me, I believe he asked what was if that diagnosis was on there, or what do you see on top?
Okay. All Children's Hospital was paid for the bed while your daughter was being sheltered there. Are you aware of that?
The bed, you said?
Correct.
Objection, that's irrelevant on that point.
Okay. Are you aware, sir? Can you tell this jury at all what percentage of the $5,980 Aetna reimbursed was for child neglect versus complex regional pain syndrome versus a throat infection versus immunoglobulin versus constipation versus abdominal pain, etc.?
That I could not.
You can take that down, Clay. No one at All Children's Hospital ever told you that Sally Smith was an employee of All Children's, true?
No, and nobody told me that she wasn't.
All Children's never told you that Sally Smith was their employee, correct?
No, but she was wearing the same lab coat.
I'm asking you, so that's a no, correct?
I said no.
Okay. And in fact, your wife knew who Sally Smith worked for, right?
I cannot speak for that.
One moment, please. We could do joint exhibit or trial exhibit 240081739. And it's in the about 2/3 of the way down the page. It says Tuesday, 10/11 Eve. I had another supersized visit. This was the email we showed earlier that Beata wrote to you. True?
Where does it say it went to me?
It says, do you want to see the date of the email again?
Please.
Okay, Clay, let's go to the first page, 1738. So I'll represent to you, this was...
Yeah, I see it.
Okay, so let's go to the next page, 24081739. Tuesday, 11 Eve, I had another supersized visit from MD Dr. Smith, who was sent by CPS to investigate this possible child and abuse and neglect case. That's what Beata wrote to you.
Okay.
Okay. Let me ask you about sir, and I apologize for having to raise this. You did have plans to have Beata move out, true?
Yes, that's true.
Okay. You had prepared divorce papers?
No. It was a legal separation.
You told Detective Graham that when Maya was released from the hospital, you would have Beata move out, true?
That was the plan.
And divorce papers were prepared.
We were going to do a legal separation.
I'm going to be as sensitive and brief as I can on this topic, sir. The hearing on Friday, it was Friday, January 6, 2017, right?
Yes.
That you talked earlier, Beata was very upset about being separated from Maya for now almost 3 months, true?
She was suffering. Anybody that would be removed from their daughter would be like that.
Okay. The 3-month separation of Maya from Beata was what was causing her this emotional heartache, true?
Most of it.
That night, you do recall Beata left with a gun, true?
That was my thought, but that was untrue after time.
Okay. You reported to the police that night that Beata had left with your gun.
I reported Beata missing and potentially, well, I said the gun's missing out of the safe, but it was in the house.
Okay. You did not believe she was suicidal that night, did you?
I was very worried about Beata. I called her family, but I was concerned when the gun was missing, but it ended up finding the gun in a long time after. She never took the gun.
But on that night of December 6th, you were not concerned that Beata was an immediate suicide risk, were you?
I was concerned that she was missing. I was concerned about her health. I called her family after she was denied in court. Her brother did fly in, but she did come home.
So that's a no. You were not worried about an immediate
I was worried about her. I told you I was always worried about her.
I wasn't asking if you were worried about your wife, sir, respectfully. I was asking if you were worried that she was at imminent risk of suicide.
Well, when I didn't find a gun, I was very concerned, and I called the police right away.
Beata never expressed suicidal ideation to you at any time, true?
She never mentioned suicide whatsoever.
And then the next day, which would be the 7th, now Saturday, January 7th, I think you said you and Kyle have gone out to a party. Is that right?
We went to a neighbor's house, a birthday party. Beata was going to go with. She had a migraine headache. That was the day after she was missing, and she came home that night. She stated she had a migraine headache. She was in bed. She did get up to wrap the present for the child. We went to the birthday party, and when we came home, the door was closed where she was sleeping. So Kyle and I sat on the couch, we watched TV. Kyle fell asleep on the couch, and then I shut the TV off and went into my bed. At that time, she was sleeping with Kyle. That was like her little security blanket. That's all she had, was that little guy. So that night, her brother, like I said, I called because I was concerned about her.
Yeah, and so just to make sure I understand the question, when you came back, you didn't check on her because you did not think she was suicidal at that moment, did you?
No, she stated she had a migraine before we left, and I let her sleep.
Okay. So, and again, just so the jury understands, at no point during this process did you believe that your wife was at imminent risk of suicide, true?
I was always concerned about her.
I'm
But
not
yes,
asking if you're
yes, it's
concerned.
true. I was always concerned about that. With all that was going on, yes.
But Beata never expressed any suicidal ideation to you in November, December, or January, true?
November, December, January. There was a report from the hospital that she, in your records or in Sally Smith's records, that somebody within the medical.
Sir, I'm asking you about report to you.
Can you please be allowed to answer the question, Your Honor?
It's non-responsive to my question. My question was very simple.
I agree. So why don't you ask your next question?
Okay. My question to you, sir, was this. Did Beata ever express any suicidal ideation to you in November 2016, December 2016, or January 2017?
She never told me that she was going to take her life, verbally.
The jury earlier saw one of the suicide notes. Do you know why Beata said, I give rights of my parental rights of Maya and Kyle to my sister and brother in Chicago?
No, I do not know.
Let me ask you a little bit about Maya after she got out of All Children's. We had a chance to talk to, at least my partner, Mr. Hunter, did, in November 2019, to give you an idea of time frame.
First depot.
Yes, sir.
Okay.
At that point, so now we are a little over 2 years after she got out of All Children's Hospital. Other than allergy medications, Maya was not on any medication, correct?
Not that I'm aware of. I would have to review that.
Okay. She had not seen anyone for asthma in over 2 years, true, by that point?
That's true, and hopefully, like we said, ketamine and hopefully the hyperbaric chamber did help for that.
Okay. Well, to be clear, after she got out of All Children's Hospital in January of 2017, she's never received any ketamine, has she?
No.
And she's never gone to hyperbaric medicine, has she?
No.
In fact, as early as 2018, you were able to scuba dive with her.
She scuba dived, but with her arms.
Okay. Well, she was back in school the next following year.
Yes, on crutches.
And she became president of her class, true?
That is true.
She was waking up at 4 a.m. Running in the morning?
Running?
She was exercising
Not running,
at 4
she
a.m.
exercising.
Okay. She, as of that point, at least when you talked to my partner, Mr. Hunter, you did not see any signs of CRPS in her at that time, true?
At that time.
Okay. And again, when we talked to you in October of 2020, you saw no signs of CRPS in her at that time either. True?
No, but unfortunately, there are signs now.
Okay. Well, let me ask you, Maya has been able to get a job working at Cracker Barrel?
She worked there. She waited tables, and she had somebody carry the heavy load.
She got back to ice skating?
For a short time, yes.
She has no physical limitations right now. True?
I wouldn't say true. She knows her physical limitations.
She was back in phys ed class.
The what? I'm sorry.
Physical education class. She was able to get back into physical education class without restrictions. True?
True, but she had problems running.
And again, in that period of time, within 2 years after she left All Children's, from your observations as her father, you did not see any signs of CRPS, correct?
It never went away, just so you know. There was pain here and there. It's not like it was a clean slate. So I would say untrue on that.
Okay, well, let me ask you about that. When you were asked on November 6, 2019, what signs or symptoms do you see of CRPS in her today? You said, I don't see signs, no evident signs. She's not complaining of pain. Her muscles are built up. There's no lesions. I don't see nothing right now.
That is correct. And I don't know if you heard earlier, she hides a lot from telling me as well.
One moment, Your Honor. Just a couple more questions, sir. The
Famous
yeah, true. The photographs that we saw earlier
Yes.
of your daughter, Beata had not seen those before she died, correct?
I wouldn't say that's correct. She would have seen some of them, yes.
No, okay, so just to be very clear, the photographs that were taken, the date that Maya was being brought to court for the DCF dependency hearing, Beata had not seen those before she passed away, correct?
No, but she heard about it.
What you had not.
I have not seen them as well.
Okay, you had not seen the photos, and she had not seen the photos. True.
Correct.
One moment. Those are the questions I have. Thank you, sir.
Thank you.
Redirect.
So those medical records had a lot of direct quotes in them, didn't they?
Medical.
The Johns Hopkins records? Well, they were trying to say what you were saying?
No, I mentioned that before. Yes.
And they kept bringing out what would be considered sort of negative information, right?
Object to the leading, Your Honor.
Overruled.
Yes, and like I stated, there was several things missing, such as lesions or dystonia, things like that.
Well, right. These are the same people who stopped documenting symptoms after a certain period of time. Is that right?
Objection, leading, and argumentative.
Sustained on that one.
What, if anything, did they do about those lesions and other symptoms after about, I don't know, October 13th or 14th?
They went from lesions to self-inflicting wounds.
So these same people have got all kinds of direct quotes, right? Isn't that true? And they've got, did any of them, and denials, and you said this is, and they believe that.
Objection, leading, vague, and argument.
Did?
Okay, I didn't understand the question, so I'm going to sustain on vagueness.
Was this the first time somebody had put into the medical records all of these types of allegations consistently against you?
Objection, again, vague, argumentative.
That one's overruled. You can answer that.
That all the hospitals did the same as
No,
what they did?
I'm asking you whether this was the first time, whether Johns Hopkins did it. Was this the first hospital that had ever put all this kind of stuff into your record?
Oh, yes. Yeah, there's quite a bit of stuff in there.
So from this perspective, were you relying on them to be the treating physicians at this point? Is that right? Johns Hopkins was supposed to be treating your daughter.
Yes.
They were not supposed to be prosecuting your family, were they?
Objection, move to strike.
I'm going to overrule that question.
I'm sorry, say it again.
They were not supposed to be trying to prosecute your family.
Absolutely not, no.
All of this stuff, correct me if I'm wrong, all of these things they put in there were after they had taken the position with the outside world that Maya was making it up and Beata was essentially a criminal.
Objection.
Is that right?
Argumentative misstates the evidence.
Sustained.
Wasn't this all after allegations of Munchausen by proxy and conversion disorder had been raised?
Same objection.
Overruled on that.
Yes.
So when you go through all of those records and compare them to the last hospital records, do you come away with the feeling that they were actually trying to help you or build a case against you?
Objection leading.
Alternative. I didn't hear your ruling.
Sustained.
What, if anything, did it appear Johns Hopkins was trying to do in those records to you?
Objection, again, argumentative misstates the evidence and lack of foundation calls for a legal.
I'm overruling that one.
My feeling, they were painting a picture that we're doing something wrong.
And they were supposed to be your daughter's doctors?
Yes.
How many times in your life had you had doctors put all of these things in your records just randomly?
Objection, vague, and argumentative. That's all these things.
Sustained.
How many times prior to Johns Hopkins had any doctors consistently put negative after negative after negative, you said this, you said that, comments in your record?
Objection, same objection.
Okay. Well, you can answer it this last time, but Mr. Anderson, you need to move on.
I'm about
You
to.
have more than amply made your point.
I understand.
So go ahead and answer it, and then we need to move on.
That's the first time.
So was Johns Hopkins, to your view, trying to get your daughter well and get you out of there?
Calls for speculation, objection.
From his perspective.
You haven't finished the question, but it also sounded like it was going to be a compound question, so let's try to rephrase the question.
Did Johns Hopkins ever come to you at any point after they first told you on the 9th that you couldn't leave and tell you, it's okay now, you can leave?
That we could leave? No.
No, that you could leave.
Was there an objection?
No, Your Honor.
Okay, no.
And so were you operating under the assumption throughout this period of time that if you took your daughter, stepped out the door to get out of there, you would be either by security to the police or to the police end up in, well, custody?
Objection to the leading, Your Honor.
Overruled on that one.
That's what we were worried about.
I want to talk for a moment about any statements to this Detective Graham. Let's take the jury to what happened there. So, what's the first time you saw this detective?
I went to visit Maya for a visitation at the hospital. That was through Kathy Beatty at the time. I had to go through the hospital social worker for visitation. When I arrived, I went upstairs to get Maya, and she wanted to go down to the cafeteria to get a piece of cake or mashed potatoes. I don't recall what she wanted, but the door opened, and Kathy Beatty was there with a Sarasota County Sheriff's investigator, female.
Now, before this time, had you had any conversations with or involvement with the police over this?
With Graham, no.
So somebody called Graham to get her over there, from the best of your knowledge?
I'm sure it was coordinated because they knew exactly where I was.
And Ms. Beatty directed her up there, is that true?
They met us at the elevator doors downstairs.
All right. So you're there to see your daughter.
Yes.
Tell the jury what happened after that.
So they wanted to speak with me, and I advised them I was just going to feed Maya. So they allowed me to go have lunch with Maya. Then I brought. And
Hang on. When she brought you inside the room, was she armed, to the best of your knowledge?
I don't recall seeing a gun.
Did it turn out later she was?
I don't.
Objection, Your Honor, speculation.
Sustained.
And so, did you know you were being recorded?
No, not at all.
She did not explain that to you?
No, she, at one point, she said she had to look out the window and pay her parking meter or something, and she reached in her purse, so obviously, maybe just changing the tape or whatever.
In her questioning, did she seem like she wanted you to testify against your wife?
Oh, yes, it was like a big wedge. Yeah.
You ever heard of flipping a witness?
Yes.
Objection, speculation.
Or a suspect?
Overruled.
You ever
Yes.
heard of? And so her questioning in there, did she or did she not warn you before any of this questioning that if you weren't going to cooperate, if you weren't going to help, that you were going to spend time in jail?
Objection.
That's on the tape.
Leading and speculative.
Well, I'm going to sustain the leading, overrule on speculation.
What did she tell you about what was going to happen if you didn't turn on your wife?
She stated that she put other people in jail for many, many years and basically do the same thing to me.
So what was your choice here?
Cooperate.
And what happens if you didn't cooperate?
Object, speculation.
Overruled.
That I didn't know. That was scary.
Well, had she already told you she was going to?
Yes, yeah, that was burnt into me right away.
Well, then your choices were what? To either testify against your wife or, from your perspective, go to jail?
Objection, argumentative, speculative.
And
Overruled.
you can answer.
Yes.
And so throughout this process, did she suggest, as we've heard, the answers to the questions in the question? You know what leading questions are, you've heard that here.
Yes.
In all of these things, did she suggest how you should answer in the question?
Yes. And then there was times where, just she had so much from the other side about all these high dosages and this drug is so dangerous. And, how dare, I don't know the exact words, so don't quote me on them, but it's basically how dare you for even doing what you did by going to Mexico, things like that.
Wait. She came in loaded with information from Johns Hopkins?
Yes.
Objection, leading, Your Honor.
Where, if any, if you're aware, I'll rephrase, where, to the best of your knowledge, would she get all of this information about your medical history?
Objection, speculation.
He knows.
Do you know?
I would assume that it came from the hospital.
I'm going to sustain the objection.
All right. Was there anyone else other than the hospital at that point who had all of that information?
No.
Logically, who was the only entity or person who could supply that information to the detective?
Objection, again, lack of foundation, speculation.
That's the predicate. It was a predicate. Never mind. So, what did you think you had to do there in order to see Maya again?
I had to cooperate.
If you wanted to take your daughter home, what did you have to do?
Oh, this was something that was discussed with the attorneys. Like I stated earlier, I had an attorney. I don't know if it was at that time. I had an attorney, Beata had an attorney, and the children had an attorney.
So she questioned you without counsel. Were your attorney there when she was questioning you?
No.
Objection, again, to the leading.
Was you?
Overruled.
So, can you tell the jury whether you were questioned without an attorney?
I was questioned without an attorney.
Did you have any help then in case she said inappropriate things to
No.
call her out on it?
No, not at all.
And so did she imply to you that if you weren't going to say yes to a lot of things, that you were going to have a great deal of problems down the road?
Yes,
And is that why you said the things you said?
I did, but then I defended myself on a lot of them. At the end, where she didn't record as well, going down the hallway, I said my wife would never do something like that.
So you told her that.
I did.
Didn't you tell her that on multiple occasions in
Yes.
that recording?
Yes.
And what did she do once you said that? Did she
Go to the next.
But wait, once you said that, did she relent and stop asking you leading questions, or did she continue trying to press you into saying negative things about
Just
your wife?
kept
Objection for leading the argument.
That's alternative.
And sustain the leading on that one.
Did she tell the jury what, if anything, she did in terms of accepting the fact that you had told her repeatedly that Beata would never do this?
that. She just repeated the question again and again type thing.
On certain occasions, did she repeat the question on multiple times?
I don't know how many times or whatever, but some were, yes.
At the hospital, during the first part of the time you were there, when Sally Smith walked in, as you testified, in a white lab coat, were you relying on Johns Hopkins in terms of not letting people wander around their hospital with a lab coat on?
An objection to leading, Your Honor.
Sustained.
What, if anything, did you rely on the hospital for in terms of keeping people with a white lab coat and the emblem on it out of your daughter's room?
Objection to the relevance.
Overruled.
What did I rely on?
No.
I'm sorry.
Did you rely on the hospital in that regard to keep people out?
Oh, yes, yes.
And so did you start to discuss things with Dr. Smith thinking that she was another doctor there?
I didn't even know her name at that time. She never introduced herself. She just came in and just started asking questions. So, yes, I thought she was a doctor for Johns Hopkins because she came in alone. She was the only one in the room with Maya and I.
So no one introduced her?
No.
Did any hospital person correct that misassumption?
No.
And did you learn later that she was, in fact, closely aligned with the hospital?
Objection mischaracterizes the evidence.
Overruled on that one.
That she was in with the hospital? Yes.
So now, in this case, and you've been following it. Excuse me. Sorry, how many times have you been deposed in this case?
5 times.
How many times has Maya been deposed?
5 times. Kyle won, I believe.
And you have stayed in touch with who are deposing and who are not deposing. You followed the case, in other words.
Yes.
And have you heard whether any psychologist or psychiatrist prior to Johns Hopkins on October 7th ever diagnosed Maya with some type of fictitious disorder?
No.
Prior to October 7th, did any psychiatrist or psychologist diagnose a Munchausen by proxy situation?
I never heard of that, no.
From your knowledge of CRPS, how unusual is it to have people at first question and consider these types of diagnoses, conversion disorder?
I wasn't really educated on that, but a lot of them are diagnosed with that, fictitious or conversion at first because they didn't get properly diagnosed with CRPS. But in Maya's instance, she was diagnosed with CRPS, after Tampa General.
You've been asked on several occasions whether during certain times, particularly, I think October 11th, On October 11th, then, how many days was it until the state actually entered an order to take your daughter? Was it on the 14th?
The 13th, I was told to leave.
So by October 11th, you were pretty much through with your week there?
Yes.
And so when Beata started to, well, let me put it this way. Was your wife shy about stating her opinion to the Johns Hopkins doctors?
No.
And were you concerned that if Beata continued to press them, they would keep Maya longer?
My personal feeling, yes.
And so, in terms of approach, did you try to present a more relaxed and not quite as intense approach than your wife?
Yes.
Now, by was it your impression, based on everything that happened to you, that the reason for your losing your daughter was because of the use of ketamine? Losing your daughter to the state was because of the use of ketamine?
Yes.
So after you got her back, tell the jury just how interested you were in trying ketamine anymore.
Well, I was instructed not to, but we've seen great results with it. And
So, continue.
there's times, we wish we were able to get her treated, and now I'm seeing her, getting a little downhill here, so I'm very concerned.
But have you remained concerned that if it gets out to another doctor that maybe doesn't know you as well, that something might happen?
Sure, absolutely.
And from your knowledge, and how old are you now?
62.
Sorry, Dad.
But I feel like 80 after today.
But has it been your experience that once something gets into your medical records, it tends to stay in
It's
your
stuck
medical
there.
records? And throughout this period of time, then, did it appear to you that Johns Hopkins had prejudged you, you and your wife?
For legal conclusion
Prejudged.
and speculation.
I can rephrase.
Yeah, prejudge, I don't understand that.
Got it.
Sustained.
Well, in reviewing the records to Tampa General, did you read where Johns Hopkins had sent over a, if you will, transfer report?
Did Tampa General send one over?
No. Did Johns Hopkins send one over to Tampa General to start this out?
We went from Lurie's to Tampa General.
I got it.
Okay.
But do you know if...
That I would be unaware of. That would have been Beata.
Fair enough. All right. So Maya tried quite a number of her old activities as she got a little better.
Yes.
Did they last?
Some.
And why didn't they last?
It was too much pain.
And what happens, what about memories of her mom? Strike it. Who introduced her to these various activities?
Well, Mom, Beata, and Kyle, they did ice skating. At first it was the two kids, and Mom was sitting on a cold bench in the ice rink. So she decided to start ice skating, and that was up in Chicago area. And then she did the same thing here. Instead of sitting there, she then, while she was doing her treatments, different patients in different locations, if she went by Ellington, she would take her lunch and skate.
Well, from what you saw, did Maya have a difficult time doing activities that she used to share with her mom?
It brings back a lot of memories, yes.
And were you pleased they were at least trying to do these things?
Yes, oh yes.
But when was it typical that when she tried an event, a sport, a hobby that had been introduced to her and supported by her mom, it didn't last very long?
Yeah, and I see that with the piano as well right now, too.
Is she playing piano much anymore?
Not much.
She played a lot before your wife died?
It was every day, and in fact, she did it in the hospital as well. She enjoyed it at that time.
So she doesn't do that anymore?
Not much.
She tried ice skating. Does she do that anymore?
No.
Of course, never got back into gymnastics.
No, and her workouts are very limited right now.
So many of the activities that she used to enjoy, can you tell the jury whether they're now no longer there or limited?
Object to the leading, Your Honor.
Overrule that objection.
A lot of them are gone.
Are you aware that she quit Cracker Barrel?
She did, yes.
Are you aware she quit Cracker Barrel after a matter of a couple weeks?
Yes, she had a dizzy spell, several dizzy spells there. And like I stated, she didn't carry the food there. She had one of the people that clean up or somebody from the kitchen carry the food. All right.
Now, let me ask you about a note that was put in front of you with Beata's handwriting that said, IV ketamine, desperate.
Yes.
Can you tell the jury how the IV ketamine was administered? Was it administered through the arm or was it mixed with something?
Yeah, this is a little confusing. Originally, after the treatments, she would get some take-home, I don't want to say take-home ketamine. She had pre-filled syringes without a needle, and it was given orally. And these were made up at King's Pharmacy in Palm Harbor, Florida. So after her treatments at Dr. Hannah's, we would have to go pick up that prescription. And these were for to give at home. It was difficult after a treatment to go to King's Pharmacy and pick it up because you have the child in the car and she just got out of the treatment, so she's tired in that. But we did that.
Well,
And
how did you administer it? Did you mix it with something?
that one was mixed. I don't know if there was a flavoring in it at that time. But then she also had ketamine ointment for her lesions, to rub on the lesions. And then after time, the cost of those pre-filled ketamines for the oral, I believe they were pretty expensive. So at one point, they went from that to ketamine IV. It was a vial, and then you pulled the ketamine out of there, mixed it with Gatorade, and then gave it by mouth, oral. But it was confusing because now you got a IV prescription for ketamine. And that would last a while, I believe, because it was bigger or something like that.
Will you please tell the jury whether you ever saw, heard, smelled, tasted anything in any way, heard from Maya, anywhere else, that Beata was giving Maya IV ketamine as an IV at home?
No.
And when Maya came in that first day, do you dispute many of the things that they put in those records?
Objection, vague.
I'm about to.
Sustained.
Do you dispute the inference from what they're saying that Maya was thrashing around needlessly? Was there purpose behind that?
I justified that earlier. Yeah, I stated she was thrashing, but it most likely because of the blood pressure. And it's like putting gasoline on a person and lighting them on fire. I'm sure if you try to take their blood pressure, they're not going to cooperate with you at that time. I hate to use that analogy, but...
You know, it's interesting. On the photographs we do have of Maya in the video, you know, she doesn't seem to be that bad. Did you make a habit of videoing her or photographing her when she was curled up in bed on a bad day?
Personally, I hate it too. It tore me up. And just seeing some of the pictures today of her little legs and her trying to lift them up, I don't want to ever, I cannot wait till this is over with to get rid of all that.
One moment, Your Honor. On the amounts, finally, on the amounts involved in and the number of entries on those Aetna billing forms, are you worried so much about the fact that it's the percentage or amount, or the fact that Johns Hopkins was telling Aetna and apparently privately saying she had CRPS, while in public and in discharge notices saying that was Munchausen by proxy?
Objection leading and Ms. Stacy.
What, if anything, was your concern?
I sustain the objection.
What, if anything, was your concern about them putting CRPS in the bills, billing Aetna for CRPS, while things like that, discharge, were saying Munchausen by proxy?
Objection leading and argumentative again.
I ask what?
Overruled on that one.
My concern was they're billing for it, but they didn't treat Maya for it, which she definitely needed treatment for CRPS.
Mr. Shapiro, any further questions?
Very briefly, you're the only one.
Checks in the mail.
And Mr. Kowalski, just to be clear, when you met with Detective Graham, everything you told her was true, correct?
Like I said, she led me to answer some questions, but I did not lie.
That's my question to you. When you met with law enforcement, were you truthful with them?
I was truthful with her,
Thank you.
but I was led to certain things.
Well, sir, whether you were led there or not, were your answers to the detective truthful or not?
Yes.
Okay, thank you.
Mr. Anderson, anything further?
Was the fact that somebody had called the sheriff's department to get her down there of concern to you?
Very concerning.
Did you believe at the time you were giving those answers you were under duress and being threatened?
Objection. It's beyond the scope. It's also argumentative.
Overruled.
I stated that earlier. Yes, I was.
No further questions?
Nothing further, Your Honor. Thank you.
Members of the jury, do any of you have any questions for Mr. Kowalski?
Sorry.
They wrote a novel.
Be here.
No.
Okay, members of the jury, I'm going to ask that you step out because it'll go faster if I don't have that white noise machine on. So this is actually to speed things up. Do not discuss this case amongst yourselves. Do not do any investigation and receive no information.
All rise for the next thing.
Jury's out of our presence. I'm going to ask that Mr. Kowalski step outside so he doesn't hear the questions ahead of time, since I don't have the white noise machine on. I do want the lawyers to stay up here because this way you can physically look at. Please be seated. Members of the jury, I want to confirm while you were away, you did not discuss this case amongst yourselves, you did no investigation, and you received no information. Is that correct? And no one approached you about this case. Is that correct? And you have not seen any media coverage. Is that correct? And just to let you know, when you walked out and I turned off the white noise machine, I asked Mr. Kowalski to step outside, so he did not hear me going over the questions with the jurors. So just wanted to let you know. And there's, I will tell you, 9 sheets of paper. 8 pages are full sheets. I got 1 page that's not a full sheet, so. Perhaps in the future we can just do a full sheet. Okay, Mr. Kowalski. I'm just going to start reading questions. And I will say to the jury, I'm going to be able to ask most of them. There's a couple that I'm not going to be able to, but almost all of them I'm able to ask. Okay. Did you file a legal separation from your wife at the advice of legal counsel to get Maya home?
I'm glad you brought that up. Yes. It was advised by the child's attorney to get a legal separation. That way Maya could come home and be out of the hospital. But, I'm sorry, it wasn't the children's attorney. It was one of Beata's or mine. And the child's attorney advised not to, because the problem there, now mom wouldn't see Kyle. She wouldn't have no kids to see. But she agreed to move out of the house to have that happen. But it was the advice of the children's attorney not to do that, because now she would be without Kyle.
When you checked into the hospital, did the hospital registration explain your rights and responsibilities, or just ask you to sign the consent form?
It was more of signing. Maya was in severe pain. There was no, they didn't explain anything at that time.
Okay. And there's a question on that sheet that I'm not going to be able to ask that last question. Mr. Kowalski, this is in regards to the hospital, or the hospital wanted passwords of Maya's social media accounts. Was this requested verbally or in writing?
They called me.
Okay. Do you recall who requested a name, a known name?
I do have it. I believe it was Child Life that wanted it, and they stated that they wanted to set up a computer for Skype. But Maya had her own computer there already, so I didn't understand why they couldn't use that one. But they wanted Maya's passwords for all her social media and that. And my recommendation was to just go ahead and use a new password and just give it to us. That'd be a lot easier.
Well, I think you were anticipating the next question. Were passwords given to the hospital?
No.
Okay. Also, was Maya allowed to use social media while in the care of the hospital?
No, she was allowed to use a computer for school. This, I think Jackie Dietert mentioned that. It was the first time the school did something like that, Skype. And then it was probably a good thing for them, a good test, because not too much longer COVID was here and everybody was learning from home. But
did the hospital keep Maya from communicating or posting via social media?
I do not believe she did any social media there at that time. Okay. That I honestly couldn't answer that one fully.
Okay. The same juror, the next page, I'm not going to be able to ask those questions. Maya was discharged with 3 to 4 diagnoses by Johns Hopkins All Children's Hospital, and none were CRPS. Is that correct?
That is correct.
Next question. When, if at all, was Maya ever examined and given a diagnosis of CRPS?
RPS, the date and the doctor name, please.
That was Dr. Anthony Kirkpatrick in Tampa, and that was after the Tampa General, so I would say, I'm guessing around August. I could be wrong on the date or the month.
Okay. The next series of questions. You are stating that the detective, after identifying herself and you agreeing to be interviewed, did not, one, place a recording device in plain view, like on the table you were sitting at. I guess, is that correct?
That is correct. It was not in view.
Is it correct that she did not ask if she can record the interview?
That is correct. She did not.
Is it correct she did not start recording and first, on the record, identify herself, title, the date, time, location, and your name as being interviewed?
I didn't hear that. I don't believe so.
Thank you. Now we're going to the next juror's questions. I have to say, I appreciate, y'all have much better handwriting than me. But my handwriting is horrible, so at least I'm able to read y'all's, so thank you. When you testified that Maya was not having withdrawal, how would pain reaction differ from withdrawal?
What I believe the question was with the withdrawal that was from the medication. She did have pain, though. She was always in pain, and like I said, it's not a constant level of pain. It could be high and it could be low. But when we were discussing withdrawal, that was in reference to ketamine. I never seen a withdrawal from ketamine.
What did you observe that helped you know the complaints were pain versus withdrawal?
Her complaints?
Yes, her being Maya's complaints.
The pain, you could see her guard, and then, her facial expressions. A withdrawal, I would imagine more shaking, things like that, like a seizure, but you could see the pain. And I know her pain, so I knew the difference, and I never witnessed a withdrawal.
Next question. When Maya had her issues on July 4th, it seems that lack of motor function and pain reaction seems like a significant development. The record showed treatment took place a few days later. When did pain climax on July 4th?
She had pain, and they first believed it was from all the steroids she received. But then later in July, I believe, July 20th, that's when we really started seeing more signs with the pain.
Again, you contemplated the next question.
I'm good at it.
How long between episode to ER treatment?
I believe there's one before the 17th, but there was one in between, I believe. I could be wrong, but I'm almost positive. But we see more pain and more problems as it went on.
If there was a delay of more than a couple hours, why?
I don't understand that one.
Okay. I'm sure the lawyers can follow up. Maya's room, when it moved, did Maya get moved often? If so, how often?
Maya did get moved, and I read in my notes just recently, she asked that question, and the nurse stated after 30 days you get moved to another room. I don't know if that's true or not, but I just read that today in my notes.
How many floors was she moved to during her stay?
I know she went from the first floor, and then the main most of the time was on the 7th floor. I could be wrong. There could be another floor involved I honestly do not remember. But all the moves to rooms was basically on the one floor of, I believe it was 7th.
And did Miss Beatty follow her through the floors?
Yes, she did.
Next question, and for the juror, I'm not going to be able to ask that next question on your list, but the following one, in your experience as a fire expert, are parents usually a trustworthy source of information during an emergency or a hindrance to EMT assessment?
We utilize the people as much as possible. If they were, there's great resource, medical, and then also fire incidents. If you have somebody in a building trapped or whatever, they may tell you exactly where they're at and how to get in there. It'd save a lot of time. We don't have this where like a football team where you could take a timeout and figure everything out. You try to get information right away and act on it. They could be a problem too, where they're trying to tell you everything to do. And as a manager, all the fire officers went through a lot of management classes. They could be a great resource or they could be a problem. And if they're a problem, you should just kind of remove them from the area so you could do your job.
Did Beata supply dosage information to her blog?
That I don't know. I never really followed the blog.
Okay. How frequently was she updating it?
That I don't know.
Okay. So you wouldn't be able to know how specific?
No, sir.
Okay. Or a police source?
The what source?
It just says police source.
Police source?
Yeah,
I honestly don't understand that.
Had you met the officer who investigated the suicide prior to the suicide?
No.
Okay. Was the local, quote, force, end quote, aware of your career?
I'm sure they were. Yeah, they do ask you your occupation and everything. In the garage, I do have my old fire code in there, so I'm sure they've seen that. But I believe they do ask you what your occupation was.
Next question. You stated you did not want your daughter to take opioids. Did you request alternative medicine the first time the opioids were prescribed?
I don't know when the first opiates were prescribed, but we looked at the hyperbaric treatment, and that was without any medication. We thought that would be a good route to go. Unfortunately, it was out of pocket, but at that point, we didn't really care. We cared about Maya more than anything. And I meant to ask the doctor about if that helps the liver too, but I'll have to find that out someday.
Well, I'm going to go ahead and ask this, although I wasn't quite sure if, based on your answer, but if the previous answer was yes, what were the options and why did you decide against the alternative medicine?
Yeah, I wasn't the one doing most of the research, but I really don't have an answer for that one.
You stated most communication went through Beata.
That is correct.
Would you read through the medical notes throughout the duration of Maya's illness to ensure you received accurate information and to ensure that there was a clear understanding of communication between Beata and the medical staff?
I did not review them in full. She would let me know. She dummied it down for me. I do not know a lot of these terms or treatments, but I had 100% trust in her.
If your brother was not approved for visitation at Johns Hopkins All Children's Hospital, how was he able to drive Maya to the Sarasota courthouse for Dr. Duncan's evaluation?
I'm from a family of 8. It was my other brother that drove Maya to the courthouse. It was not Bob. That was through the court.
During the time of the surveillance video at Johns Hopkins, do you know if medical orders were placed that required Maya to have assistance getting out of bed because of safety concerns?
I'm unaware of that.
Page 8. At any time has Johns Hopkins All Children's Hospital staff, and I guess this is if you know, at any time has Johns Hopkins All Children's Hospital staff been trained on CRPS, how to treat, and when did that training take place?
That I do not know.
And for this juror, I cannot ask the next question. The next question, Kathy Beatty, does Kathy Beatty work at Johns Hopkins All Children's Hospital or CPS or DCF? And is she still working there?
I believe she was an employee of the hospital and she's no longer working there.
And the last page, the page that isn't the full page. It's missing its friend. Okay. Was an assessment or investigation ever conducted on the family to either confirm or rule out the Munchausen allegation?
All family members, we had to go for a forensic psych evaluation. That was through Dr. Duncan. And I believe that's what they were trying to use that to rule it out. And I believe we heard Dr. Duncan with her findings.
And then the next question is, if so, by whom?
Dr. Duncan.
Okay. Members of the jury, that concludes the questions that were given to me. We're at 5:25. I see we've got one more. Let me ask you this. I'm sure the plaintiffs and the defense are going to have follow-up questions. We're at 5:25.
I don't, Your Honor, if that helps for timekeeping, but it's up to you.
Okay. Do you want to finish this witness, which might be 5, 10, 15, 20 minutes, or do you want to leave for the day? Okay, so what I'm going to do, I was just handed another question, but for the sake of time, I'm going to let Mr. Anderson ask his questions. Then we'll see if Mr. Shapiro has any questions. And then we'll go back to see if there's any further questions in addition to this question.
Jack, you were asked about whether the hospital had any training in CRPS. Were you told that they did not have a pain clinic, and that was why they wanted to transfer you to Nemours?
Objection, hearsay.
Overruled.
At that time, I know they did not have a CRPS program. I know I could be wrong, but I believe it was Dr. Elliott saying that they're in the future gonna have one. But at that time, I believe there was not.
Was the excuse to transfer you that they did not have a pain clinic or CRPS program when you all came in?
Is it true?
Yes.
That is true. At that time, they did not, according to Dr. Elliott.
All right. And I'm trying to read the questions too. You were asked about, I think, I have a question for the court. We'll take it up in a moment. On the 4th of July, there was a question asked about how soon you got treatment after Maya had the event on the 4th of July. Did you take her to the ER immediately?
Yes, Beata took her to, I believe that one was Sarasota Memorial, and that's when they only had their main campus. So it was in downtown Sarasota.
During the time you were there, how many rooms did she end up going through? And if you recall from the...
I'm going to guess 3 to 4.
When you were on the inspection, did you point out 5 or more?
Most likely.
And was it true that during the times that you visited her, you were less than 30 days between visits and she would be in different rooms?
Objection, again, leaving a lack of foundation.
Overruled. You can answer.
There's times I'm sure it was less than 30 days, yes. If you did the math, yes, it would be.
I think what the jury wants to know was that did that appear, that whole move every 30 days appear true to you or a excuse for moving her 4 or 5 different rooms?
Objection, foundation, argument.
Overruled, you can answer.
I'm sorry, can you repeat that?
Sure. I think what the jurors are interested in knowing is whether that moving her to a different floor every 30 days was, to you, did you take that as a true reason, or was that an excuse based on what you saw?
I don't think it was a true reason. I would believe it would be an inconvenience for them to move everything every 30 days.
So in your experience in visiting her, did you go to different rooms within a 30-day period?
Yes.
All right. And you'd been asked a question about them being trained in CRPS. I think we've already covered that. One more. I see. Through the time that Maya took, had the ketamine infusions, did you learn or see whether it affected her liver or not? Did her liver functions remain normal throughout all of that?
This objection is beyond the scope of the questions presented.
No, it's
You can
about.
answer.
I know it affected it, but it would come down. I am not a doctor, and I think the best place to find that is maybe in their Dr. Hanna, Dr. Kirkpatrick, or Cantu's medical records. But I know it wasn't a big concern.
So was it actually during the infusion that they would have some variance, and then afterward nothing?
I believe.
I'm sorry, Mr. Kowalski. Again, it's leading and it's lack of foundation based on the last answer.
Overruled.
Yeah, I believe it was a short term during, but I personally don't know exactly.
Fair enough. Finally you were asked about the decision, not the decision, but the option of filing for legal separation. Was that because you no longer loved Beata, or was it a tactical decision to try to get Maya out of that hospital?
It was nothing about not loving my wife. It was about getting Maya out, and Beata was 100% compliant with that.
And throughout this entire period of time, despite all of the tension, did you continue to love your wife?
100%.
Are you finished, Mr. Anderson?
I'm sorry.
Yes, sir.
Okay. Mr. Shapiro, did you
I
have,
don't have questions, thank you, Your Honor.
so no questions?
No questions.
Members of the jury, do you all have any further questions? I know there's one, but is there any other questions from anyone? So can I have the attorneys up here for just this one? Okay, Mr. Kowalski, after being released from Johns Hopkins All Children's Hospital in January, I know the question says 2016, but I think it's 2017 is what the juror meant. So after being released from the hospital in January of 2017, has Maya ever been re-diagnosed with CRPS, or are those the 3 or 4 diagnoses from the hospital or the last?
I believe with Dr. Chopra, he stated once you have it, you always have it. She was never re-diagnosed. She did do a follow-up with Dr. Anthony Kirkpatrick with no treatments, but he did see improvement in her condition, but he sees that there is still CRPS.
Any follow-up?
Jack, the November 2020 admission.
Yes, that was at Arnold Palmer Hospital.
Was there not a diagnosis on that?
Yes, I'm sorry, I completely forgot about that one. And that was, we were in the hospital for a week on that one.
Defense.
No other questions, Your Honor.
Members of the jury, any other questions? I see you're all packing up, so what we're going to do is we're going to call it a day. Please do not discuss this case amongst yourselves. Do not do any investigation and receive no information. We will meet at the regular time tomorrow. Yes, I'm aware there's a national emergency alert that all our cell phones are going to be going off. And we're going to put all the cell phones right in your box. No, we'll take care of it. So with that, if you could just follow Deputy Coley out, have a great evening.
All right, for a second.
Get off the hot seat there. Let me just add this up so I know you're going to ask. The plaintiffs. Okay, the plaintiffs consumed 3 hours, 25 minutes. The defense consumed 1 hour, 40 minutes. So the plaintiff's running total is 20 hours, 35 minutes. The defense's running total is 6 hours, 35 minutes. Are there any issues we absolutely have to deal with today before we leave, or we finish for the day?
I am sad to report that, well, Nick just informed me, we got a text or a call from Dr. Newberger's wife, and he is in the hospital. Did he say critical care or just in the hospital or what?
They're trying to diagnose, so I don't know that. Yeah, so that.
But he's still in the hospital?
Yes.
So we may end up, the court's in diligence, having to play that depot.
Well, thank you for letting us know. It wasn't going to happen tomorrow anyway, so everyone's aware now. So we'll deal with that. Is there anything that we have to deal with tonight?
Not
No,
that
Your
we're
Honor.
aware of.
Not from the defense, Your Honor.
Okay. Are we comfortable coming at 8:30 as opposed to 8:15 tomorrow?
Yes, Your Honor.
Yes, I am.
I would like to try to resolve that limiting instruction while the jury still remembers they had a witness.
Well, if we have time tomorrow, just muscle your way to the front of the line, Mr. Altenberg.
Okay.
Okay, we'll be in recess until 8:30 tomorrow morning.